studying the source now. Supreme elite. New empire talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee into case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss into last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme elite team, university. Turn the credit score into currency. Turn the closed door to a first key. Turn a side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme elite team, that's the school stamp. Wave it. From the first lay bill to the full camp. New culture empire, watch the flag plan. From the bench to the block, he reversed that. Put the power in the pen, yeah, he birthed that. Every mind that he frees, that's a verse that. Whole culture on the rise, you can search that. Hey. Thomas is the blueprint. Write that in the sky, let the blueprint. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Studying the source now. Supreme elite.
You're rocking with the DJ that keeps the hits coming.
Gotcha, bitch.
Credit no, I couldn't let them get me caught in front of the house inside Mercedes Benz GLE was something wasn't right, I had to do it right. Yeah. Sent the email with the proof, then I filed a suit.
You're rocking with the best.
Then they call us true, just like that, gone. They settle quick, title on the way, and the debt was wiped away, and I ain't even had to pay. No, push the whip with a drip. You know I got the stick. You know I say the case. You know that they legit. Hey, proceed be the way. If you know how to play, get the win, drop order, then you get on out of the way. 50K right away. Thomas did it right. Now these haters gotta say that Thomas did it right. Go real talk about what to do, but Thomas did it right. No guessing about the law, cause Thomas did it right. Interest rates high, but Thomas couldn't stand it. They try to take advantage, couldn't put him in a panic. Little with the knowledge, running through his pockets, funds charging through the roof. Feel like Houston on a rocket. I landed in the booth, litigation like a pro. Tell me what you say. Guru filing lawsuits, but never wanna pay. Who bad is me? Balance sheet in the court, casualty, might litigate her majesty. Y'all ain't even have his mid, going in for the win. In this game you sink or swim, undercurrents pull you in. On cap from the brim, better take it on the chin. Arbitration got his truck, got him faking, sent his shots. With the cases running laps, round these places they ain't try, didn't fight. Through the bait, didn't even bite. Guru talking like they know, but the law can't even sight. Got a Benz out the deal and then pay the full price. When they talk about Thomas, gotta say he did it right, did it right, did it right. Brothers who didn't fight, got Benz out the deal, never paid the full price. Did it right, when the court, when the fight. Over 50K in debt, white away, Thomas did it right. Slapped a lawsuit on it, this, they ain't in put up a fight. But these gurus out of sight, out of sight, out of sight. They watch his streams out of spite, mix them up, grab a Sprite. Get a job, get a life, celebrate, bring the hate. Eat these gurus, say your grace. Grab a fork, scrape the plate, they kept online, saving face. Drop receipts, play the tapes, where Kiana at? With her cheap, all masterclass. So for $25, and I'm talking at the text. That check ain't by the home, what's coming out of that? Forensics laws been silent, that's always the head of man. At a Thomas win, drop receipt, wash your hand, rinse repeat. They hate your boy, the Socrates, the new culture, no compete. Case one ain't heard a piece. Johnny Young, I'm emergency. Poppy's ish, rocket shit, they never like, but caught a glimpse. Calling bluffs, I call it quick. Silence me, they calling quits. 2 bins caught in my drip, won't come and ever hold my clips. Watch the live, gems come, fed like birds, bread comes. Midwest a dead bum, he need a life of spare one. Supreme elite, Kings elite, we moving fast, they retreat. CAC, we in the beef, settled out, keys with me. Over 50K in debt, white away, Thomas did it right. Slide a lawsuit on the desk, they ain't even put up a fight. Where these gurus out of sight, out of sight, out of sight. They watch his streams out of spite, mix them up, grab a Sprite. Get a job, get a life, celebrate, bring the hate. Eat these gurus, say your grace. Grab a fork, scrape the plate, they kept online, saving face. Drop receipts, play the tapes, where Kiana at? With a cheap, all masterclass. Teaching for $25, and I'm talking at the text. That check ain't by the home, what's coming after that? Forensics laws been silent, that's always a head over. Done with the head over, done with the head, done with the head over.
So I find it, why is going into court so much of a bad thing when millions of companies and millions of corporations go into court every day to settle disputes? They settle disputes every day by going into court. But now we're not supposed to go into court.
His documents are so powerful. They think it's artificial intelligence. Scalpel engaged, another myth is sight, ready to be destroyed.
You're rocking with the best.
Gotcha, bitch!
This show is not suitable for all audiences. Listener discretion is advised.
No way.
You're rocking with the best.
No way.
You're rocking with the best.
You have case law.
You're rocking with the best.
Straight to it. Straight to it. Welcome to another edition of the New Culture Empire. We are back in the building. The grind never stops. We build this plane while we fly it. We taking this show on the road. As you see, I'm on the road. We are taking this show on the road, and we are about to really get into it. Now, today, today I have a treat for all of you. Now, you've heard it online. You've heard them say it. You've heard them teach it. You heard them preach it. And when I came on the scene, I said, no, y'all, that's not the right way to go. It's been rejected for the last 40 years. And I was met with, I said, okay. So my new mantra now is, if you don't want to listen to me, then I will let the judge tell you. Now, remember in my last stream, I said, why do they always want to shy you away from court? And one of the things that I've noticed about shying him away from court is, we're going to cue that up in a second. One of the reasons why I shied them from court is I always wanted to understand, why are they saying don't go into court? So before we get started, let me share my screen, because us legal people, we always, it's called laying a foundation before you get to your point. Lay your foundation. So this is what we're about to do. We're just going to lay a foundation. Okay, so this is not.
That I call peaceful non-compliance, then try to attend a court of their making. So if you go to court under the impression that you are going to get justice, you are in for a big shock. Once you enter the court, do not believe for a second that you have any rights, God-given or even granted by man. You have no rights. Do not go to court and tell them that you have rights. Don't say, I have my God-given inalienable rights. Do not do it, because you truly have no rights once you have entered that ship. All you have are services, privileges, and benefits. What that tells you is that you are a slave. What are your privileges? Well, you can go to jail. That is a privilege. What are your benefits? You can pay tax to them. That is a benefit. I'm unsure who it actually benefits, but it is definitely benefiting someone other than you. The entire system is rigged, and the odds are all stacked in the favor of your overlords, these so-called elites. I prefer the term parasites. You can't win in their courts. There is no remedy in their courts. When you enter a court which is their court, you are going on board the slave ship. Truly, the only time you should enter any court is when wearing shorts and carrying a tennis racket. Otherwise, I would never.
Now, what do you see? You have no rights. Don't go to court. You can never win in court. No, don't go. Okay, hold on.
You don't have to go to court. I don't care what your criminal, what kind of a crime you've committed. I don't care how big it is. You don't have to go to court.
You don't? What do you have?
No.
What if you
You have to you have to fill out a particular kind of form, send it to the Secretary of State, and say to the Secretary of State, I wish to settle out of court. You can settle anything out of court.
You can.
Of course. If Ford Motor Company is suing General Motors, they can settle out of court. So you won't know what they did to settle the thing because it's out of court.
Out of the water.
It's out of the water, right?
Right.
Now, that's partially true. You can settle out of court. But what he left out is, in order for you to settle out of court, there has to be an action initiated in court. Let's do another one.
You will go to court if you have collections.
Now, does this happen for every single person? Not always, but after 3 years, this client was taken to court with a judgment. Now this client has to hire an attorney, probably going to pay high interest fees, and also have to pay the collection amount, which she could have negotiated way lower before. If you have a collection where it's been there for a year, 2, 3 years, they can take you to court for the next 7 years, guys. So if you need assistance with disputing collections,
another, don't go to court.
What advice, information, life experience would you give to men who are currently in situations where they're not being able to see their kids?
Okay. Ready. Now look at this. Aim. Fire. All administrative documents. So you get the point. You get what I'm trying to say now, right? Well, hold on.
I've been working all the summer, getting my bread up and shit, moving from place to place, from play to play, spreading my word out and shit.
10 reasons why not to go to court. Right here.
You are not allowed to direct anyone, not even your priest or your religious person that you may have, to contact Ms. Bain. You are not allowed to direct.
Look at these horror stories. Look, okay, so we got that out of the way, right? We got that out of the way, right? So the consensus is don't go to court. Don't go to court. Don't waste your time in court. Don't do anything that has to do with court, right? Okay, so now that we got that out the way, so the consensus is you don't go to court because you're not going to win. You don't have any rights in court. But what I'm about to show you is the real reason why they say don't go to court. The real reason why they say don't go to court. Don't go to court. Don't go to court. Don't go to court. I want you to take about 10, 15 seconds, if you will, and share the stream wherever you at, because what we are about to read, I guarantee you're going to find it on TikTok. You're going to find it on Facebook. You're going to find it on X. You're going to find it on Rumble. You're going to find it on all these social media platforms that no matter which way they go about doing it, no matter what words they put on it, you are going to read for yourself the core beliefs of 98.9999999% of people who have gone down these paths and who has done processes, submitted documents, regardless if you reject the name of a sovereign citizen, regardless if you say there's no such thing as a sovereign citizen. Oh, you can't be sovereign and a citizen, or a sovereign citizen is an oxymoron. Regardless of the script they told you to respond with, you are going to find 98.99% of people's belief system in this court case. Take 15 seconds and please share the stream. Oh yeah, we are definitely about to get into it. Whoa, they studying the source. Whoa, tell them to come on in here.
New Empire talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee in the case law. He judge bang gavel. He skip a beat. They like how you flip stress in the assets.
Alright.
How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print.
Whoa! Yeah, let's get it. All right. Let's go.
You're rocking with the best.
Let's get it. Think, brother, man. Think, They think, And one of the reasons I found it so funny, When they telling y'all not to go to court, it's because they already tried it. And they read stuff like this. So they say, damn, we ain't gonna be able to go to court and get this victory. So y'all, we gonna do an administrative process. This is why they tell you not to go to court. In the United States Court of Federal Claims, December 4, 2017, some of y'all wasn't even on this path. Some of y'all just came to this path a year or two ago. A Rule 12B1 motion to dismiss. Now, what I don't want you to do is get caught up on the name sovereign citizen. Don't take the name out of it. This is not about labeling anyone a sovereign citizen. This is not about the name sovereign citizen. This is all about the inner beliefs. The inner beliefs from people who actually stood on the name sovereign citizen, and the actions and the documents and the ideologies, and the people who reject the name of the term sovereign citizen, but the actions, documents, and the ideologies are the same. So once again, you have a group of people who are standing on the name and doing the documents that are indicative of people who think like that. But then you have today, you got people who reject the name, but are still doing the same documents and processes that are indicative of the people who accept the name. So, Rule 12B1 motion to dismiss. Rejection of sovereign citizen theory. Constitutional claims, not money mandating. Gregory Allen Davenport. This is Nichols, Georgia. Pro se plaintiff. Wheeler, Judge Wheeler. Gregory Allen Davenport is currently incarcerated. A currently incarcerated pro se plaintiff seeks relief in this court, claiming that the government nationalized him through his birth certificate and social security documents. Let's stop right there. Isn't one of the core beliefs the social security number? Isn't one of the core beliefs starts with the social security number? Doesn't it start with the social security number? Isn't that right there? The social security number, put a check right there, social security number. Thereby violating statutes and constitutional provisions. Mr. Davenport also claims to have created his own sovereign entity and renounces his United States citizenship. What's your own sovereign entity? The all caps name, the trust, the estate. The government has filed a motion to dismiss for lack of subject matter jurisdiction. Mr. Davenport has filed a motion for summary judgment. Oh, man. For reasons explained below, the court grants the government's motions to dismiss and denies Mr. Davenport's motion for summary judgment. Background. Mr. Davenport is being held at Coffee Correctional Facility in Nichols, Georgia for armed robbery, aggravated assault, and related criminal charges. And one thing about the penal systems in the United States, it is a melting pot for sovereign citizen theories, because a lot of them try to use these theories to get out of prison, whereas people in society are mainly using these theories to extract large sums of money from the government or get out of their financial obligation to pay a bill. I mean, it's never because this is what they really believe. This is how they live their life. They're never going off the grid. You don't see them in their own town. You don't see them building their own houses by hand. You don't see them kids being born at home, homeschool, their own community, and the only thing that they do is barter. No, they don't go off the grid. Y'all don't go off the grid. Y'all very much dependent on the same system that you say you hate. But let's keep going. In order to, okay, we can move second one. In his complaint, Mr. Davenport alleges that the federal government nationalized him through his birth certificate and social security documents, enabling the government to assign his properties and assets to the Federal Reserve System. I don't care how you word it. I don't care which steps you go about to express it. That is one of the core beliefs of 98.99% of people in these spaces. In order to recover said assets, Mr. Davenport demands the closure of an alleged trust account derived from the nationalization process and claims to renounce his U.S. citizenship. The alleged trust account, that is the nucleus of why many people do what they do. In lieu of his United States citizenship, Mr. Davenport instead declares himself to be a sovereign citizen with his own constitution, flag, anthem, and pledge. Just because you don't like the name sovereign citizen, what do you see this with the Moors? We got our Moors flag. We got our own temple. We got our own everything. Mr. Davenport claims that the government has violated the following statutes, provisions, and amendments of the United States Constitution. The 11th Amendment in its exercise of judicial powers, the 4th, 5th, Due Process Clause, 8th, and 13th Amendments for the claim nationalization. Regardless if he's using nationalization or many people using other things, those are the main amendments that you see them do. You see these amendments. The Foreign Sovereign Immunities Act, 28 U.S.C. 1604. Criminal statutes within Title 18 of the United States Code. Remember how the same people, they always cite 1218 U.S.C. in their documents, like the government and courts haven't already said that Title 18 U.S.C. is for federal prosecutors and private individuals have no cause of action by citing Title 18. Just like you try to cite Title 12 as part of your authority, and they only are related to the banks and the Office of the Comptroller of the Currency and the other regulatory agencies that governs them. You can't use Title 12 as any part of what you're trying to do, but that doesn't matter. We're going to keep going. The Sherman Act, 15 U.S.C. 1 and 2, and the Social Security Act, Title 42 U.S.C. 408. How many times have you seen people talk about Social Security Act on here? And there we go. Mr. Davenport seeks immediate release from Coffee Correctional Facility, and look at the amount. Typical sovereign citizen, regardless if you go by the name or not, look at the amounts that y'all be doing stuff for. Look at the outrageous amounts y'all be doing stuff for. $300,000 withholdings, $250 million bond you send to the Treasury. Remember I told you? People with remember, it's a bottomless pit. All you had to do is say, hey, I got an unlimited amount in credit. And you can tell the type of people and their level of greed and desperation just by the monetary amounts that they put on their frivolous documents. $202,500,000 in damages and closure of any accounts derived from its purported nationalization. The government filed a Rule 12b-1 motion to dismiss on September 27, 2017. This is almost 10 years ago. And this is one of the reasons why many people today don't even attempt to try to step to the government with this crap. This is why they do administrative. They're not going to go into court with this stuff today. And this is the reason why. Newsflash. If you can't prove that you can win in court on your claims, or the likelihood of you succeeding in court on your claims, then just because you're taking the non-court way, going administrative, it doesn't make your chances of succeed any higher. Mr. Davenport, okay, the government filed a Rule 12b-1 motion to dismiss on September 27, 2017. The government presents two grounds for dismissal for lack of subject matter jurisdiction. First, it argues that the court should reject Mr. Davenport's sovereign citizen claims and demand for payment based on this theory. Second, argues that the court lacks jurisdictions to entertain Mr. Davenport's constitutional and statutory claims. Mr. Davenport filed a response on October 10, 2017, defending his complaint and asserting a Fifth Amendment takings violations for the processing of information such as DNA fingerprints without compensation. What do you see today when people talk about that? you see the fee schedule. This is the fee schedule. Has anyone ever got their fee schedule honored, recognized in cash by any agency? You know when they be online talking about, nah, because I got my fee schedule. Has anyone ever got their fee schedule cash? Now, the government filed its reply to Mr. Davenport's response brief on October 19th. Mr. Davenport then found a surreply on November 2nd, claiming that government counsel agreed to settlement. The government denied this assertion on October 9th. On November 9th. On November 20th, 2017, Mr. Davenport filed a motion for summary judgment stating that both parties agreed about the important facts and again claimed that the government agreed to settlement. The court has deemed oral arguments unnecessary. You know what that means? Like we don't even have to have a hearing on this. The Tucker Act ordinarily is the focus of subject matter jurisdiction of this court. So that's more than likely when you bring a court of federal claims action against the government based on your secret account in your estate, you're basically bringing a claim under the Tucker Act. So this is where it moves from your beliefs and your theories and what you heard on a packet or that confirmation bias document that someone put together and posted online, and you take that as law. The Tucker Act states, the United States Court of Federal Claims shall have jurisdiction to render judgment upon any claim against the United States founded either upon the Constitution or any act of Congress or any regulation of an executive department or upon any express or implied contract with the United States or for liquidated or unliquidated damages in cases not sounding in tort. Now, if there was an express contract, implied contract, founded upon the Constitution, an act of Congress, or any regulation of an executive department that remotely resembles the theories or confirms the theories that you see online today, then the Court of Federal Claims would be a proper venue. Because what do you always say? Y'all always cite the Constitution for your claims. Y'all cite acts of Congress. What do y'all cite? HJR 192. That's an act of Congress. Y'all cite your regulations. So let's just, why not? Why not bring your claims here? 28 USC 1491 subsection A1. The Tucker Act does not create a cause of action. It's one of the biggest misconceptions right there. Case law, RHI Holdings, Inc. versus United States. Thus, a plaintiff must identify a separate source of substantive law that creates the right to money damages in order to invoke the court's jurisdiction over a claim. So, where is the substantive law that you can cite that entitles you to any money from the Treasury based on your birth certificate, social security number? Where's the substantive law at? And this is the part where what you read online runs smack into the legal reality. Now, let's proceed. Failure to establish jurisdiction under the Turk. Come on, y'all. Tap the screen. Hit the like, hit the share. These ain't my opinions. This is straight from the court. This is almost 10 years ago. If you're going to be upset or whatever, at least you can't be upset at me. You're going to have to be upset with the court. Not me. I'm not doing anything wrong here. I'm reading and comprehending. Y'all can follow. Y'all know that shit ain't work. You know you ain't seen a dime out that secret trust in your whole lives. Come on now. Come on, y'all. Let's not do that. Failure to establish jurisdiction under the Tucker Act requires the court to dismiss under Rule 12b-1. Outlaw versus United States. When deciding a Rule 12b-1 motion to dismiss, A court must assume all the undisputed facts in the complaint are true and draw reasonable inferences in the non-movement's favor. Courts hold pleadings made by pro se plaintiffs to a less stringent standard and liberally construe language in the plaintiff's favor. However, none of Mr. Davenport's claims survives a Rule 12B motion to dismiss. But before we go, the problem with that is, if all his assertions about the account, the estate, being sovereign, if none of that survives, and I'm talking about not the name, I'm talking about the actions, the beliefs. If his belief systems don't survive in court, then your belief systems are not going to survive in court. And this is why they tell you to stay out of court. A sovereign citizen claim. Now I need everybody to brace yourselves. This is not me. This is the judge. The sovereign citizen movement is one in which members seek to recover money from the United States. Now, take away the name sovereign citizen and focus on the processes that you're doing. Tell me you're not doing a process that is not some shape, form, or fashion surrounded around money. Whether it's not have to pay a bill anymore, or to get free money via a tax return, or from an estate, or through your worthless bonds that you send to the Treasury. Tell me one of the underlying reasons why you do what you do is for money. Just tell me it's not. At times, claiming that the government tricked or coerced them by using identifying information, e.g., birth certificates and social security documents, as security for the national debt. That has been the theory that's been floating around these spaces for well over 40 years. That's the nuke. That's how it all starts. You were tricked. A separate entity was created through the birth certificate and the social security number. And they tricked you into being surety for that. You see? So your original belief is, I'm a victim of something. I'm a victim of them tricking me. See, Gravitt versus United States. You got another case. Proponents of the sovereign citizen theory allege that this security interest results in the creation of an individual trust account containing that individual's profits. That is the number one reason why people even embark on these paths. Right there. Davenport claims to be a sovereign citizen and seeks closure of his trust account. What's the difference between Davenport and 98.99% of people you see online today? What's the difference? If we're talking beliefs, ideologies, documents, and the things that they do, what makes him so different from the people out here? What makes him so different? What makes him different? See, we're going to move past the name because people like to try to deflect. Oh, I'm not sorry. No, we're not talking about the name. We're talking about the underlying beliefs and ideologies that you possess. The Tucker Act precludes sovereign citizen claims as neither birth certificates nor social security numbers recognize or impose contractual rights, obligations, or duties. As such, this court has held that claims involving sovereign citizen theory are nonsensical and should be dismissed as frivolous pursuant to 28 U.S.C. 1915a, which requiring the court to dismiss claims which are frivolous, malicious, or fail to state a claim upon which relief may be granted. And this is why they tell you don't go into court. That's your right, meaning these theories won't be recognized. This is why they tell you don't go into court. As the Tucker Act precludes, the sovereign citizen theory in this court does not recognize the theory as a cognizable claim. The court dismisses Mr. Davenport's sovereign citizen claim for lack of subject matter jurisdiction. Now, lack of subject matter jurisdiction, it doesn't mean, well, he went to the wrong venue, he should have went here. No, what it means is the claims are so frivolous and nonsensical that we can't even entertain them in any court situated in the United States of America or in Canada or in the UK somewhere. Statutory claims. Mr. Davenport contends that the government has violated the International Claims Settlement Act for the alleged taking of property. Criminal statutes within Title 18 of the United States Code for the supposed use of false documents. Deprivation of color of law. Isn't that a term that you see online all here? Huh? Don't they say that? Deprivation of color of law. Don't they say that on here? Conspiracy. That's a big word that they like to use. Treason and other acts. And the Social Security Act, Title 42 U.S.C. Section 408 for using this Social Security number. Can I ask yourself? Can we do a little experiment right quick? What does the back of a Social Security card say? I think we have one right here. It says here, this card belongs to the Social Security Administration, and you must return it if we ask for it. I thought you were putting your Social Security number into a trust as your property. Well, it doesn't look like you actually even own that. But come on, let's keep going. Mr. Davenport also alleged government violations under 28 U.S.C. 1604 for purportedly subjecting him to its jurisdiction in the Sherman Act for limiting his options for legal representation and trading on a fund using his birth certificate. Remember, what's the difference? He says trading on a fund using his birth certificates. They say online that your birth certificate was traded on the stock market. And now you got to grab your QSIP. Remember when you could pay $200 to get your QSIP numbers, in which they go find random QSIPs, put that on a piece of paper, find funds, change the names around, and then they type in those monetary amounts for you. And then you go put that on your tax return on numbers that were made up in someone's head that you paid $200, because the inner reason why you did it, because you thought it was a good deal to get $200 to get $100 million back. But did you ever stop and ask that person you paid the $200 to, well, have you gotten yours? If the answer is yes, the next question is, well, why do I even know you exist? You have $100 million. Why are you messing around with services for $200? You have $100 million. You got a refund check for $100 million. Why do you need my $200? See, these are the little things that people refuse to, questions that they don't want to ask, because deep down inside they know the truth. And the reason that deep down inside that they know the truth, then the truth means what I want to happen is not going to happen. And I need what I want to happen based on my circumstances. That's all it is. The court lacks jurisdiction to review claims pursuant to the International Claims Settlement Act, which allows United States citizens to assert claims against foreign nations arising from nationalization or the taking of other property. If that ain't a misinterpretation of the statute on this end, because it really, I mean, what foreign nation is he talking about? Oh, let me guess. The United States is foreign now. Okay. Similarly, the court does not exercise jurisdiction over criminal claims, deeming allegations of criminal acts under Title 18 of the United States Code improper in this court. You see how they slap in Title 8? This is a court of federal claims, but this is what they all do. They take everything that doesn't belong inside the venue and they stick it on a document. They'll have 5,000 4,000 different claims, which 4,999 don't even belong in a courtroom, which they bring in a claim in, and they'll throw things at the wall and hope it sticks. This is the reason why many people will not get any type of real results, because the little basics that you have to do, the basics of following the rules, has totally left this space. Following the simple rules is like giving a 4-year-old a root canal. You don't even want to follow the rules. Further, this court held that sovereign immunity claims based on the FSAI are not money mandating. The Sherman Act, an antitrust statute, is not money mandating. So you're misciting statutes. In addition to this limitation, the United States federal district courts have exclusive jurisdiction over the Sherman Act allegations, so this court may not entertain such a claim. Each of Mr. Davenport's statutory arguments is either outside of this court's purview or is not money mandating, as required by the Tucker Act. You know what this is? This is court rules of procedure. I told you, many people, the mere fact that they even filed their complaint, they've already lost their case, because they never followed the court rules. They never have the venue down proper. They never have the claims that the court can entertain. But whatever. Constitutional claims. Mr. Davenport also asserts violations of his constitutional rights. In his complaint, he alleged that the nationalization process infringes upon his 4th, 5th, and 8th Amendments. However, this court does not have jurisdiction over violations of these amendments because these provisions do not invoke monetary damages. Remember, he's here to get money from the government. Mr. Davenport also mentions violations of the 11th and 13th Amendments. The court does not have jurisdiction over these either. Y'all, if you're not going to tap the screen because of what I'm reading, at least tap the screen because I'm not lying to you. Because I'm not changing the words. I'm not manipulating the words. I would rather you get smacked in the face with reality and stop in your tracks and about face and abort mission, rather than you purposely disregard anything that doesn't comport with what you believe or what you want to happen, so you can continue in your own dream chasing something that's never going to turn into reality. I'm going to say this again. You will never access that secret trust because it doesn't exist. Okay. Mr. Davenport also mentions violations of the 11th and 13th Amendments. The court does not have jurisdiction over these amendments either. As a result, Mr. Davenport's constitutional claims cannot succeed. The 5th Amendment is unique in that, while its due process clause is not money mandating, a 5th Amendment's taking clause may result in monetary damages. So when I told people 2 years ago, if you're going to cite the 5th Amendment, you're going to have to cite the 5th Amendment under the takings clause. And you're going to have to prove how your private property was taken and you was not justly compensated for it. Well, the claims and theories in these spaces is that our private property was taken for public use, for benefit of the government, for the Federal Reserve, and we wasn't compensated for it. So why aren't people winning in court on that theory right there under the 5th Amendment? Huh? Ask yourself that. Therefore, this court processes jurisdiction over takings claims. Mr. Davenport explicitly asserts a 5th Amendment due process violation in his complaint, claiming that the government unlawfully claims admiralty jurisdiction without a valid contract. Hold on. Hold on. Give me 1 second. Oh, give me 1 second. Hold on. Are we talking about this? Hold on. Hold on 1 second. I got a flashback. Are we talking about this admiralty? The biggest hurdles that all of you jurisdiction people going to get over, can't get around, is that the courts have jurisdiction. Number one, based on the 10th Amendment. So all this common law court or admiralty court, Admiralty courts are for crimes committed at the seas, the naval, the ocean.
Now, for everybody that came on my on my stream, over 116 comments. Do you know that when I was talking in this post, do you realize that law of admiralty, I had the statute posted? So they didn't want to read the statute, refused to read the statute, and kept saying incorrect. Look at big God or what? Incorrect. I told you, it's always these avatar, these ancient Egyptian, half human, half animal with the crown and the Egyptian stars and all this esoteric people avatar that are the most far gone down the sovereign citizen lane. The law of admiralty law or maritime law refers to a body of law relating to the seas and navigable bodies of water. Admiralty law extends to incidents that occur on the oceans, lakes, rivers, canals, and wetlands. However, admiralty law does not extend to bodies of water that are not navigable and not used in interstate commerce, such as a creek, pond, or a stream. Right there. It didn't say nothing about your state traffic court. It didn't say nothing about you getting pulled over for not having a driver's license. It didn't say that. So the mere fact that I actually had the statute there and wasn't talking out the side of my neck, and people was like, no, that's wrong because the courts have zoning codes and the naval and the zones of the Navy and then the Navy zones, and they every now and then they take up the pavement and they put water down so the Navy can come through and do the inspection of the. Shut the hell up. And this is why people won't win. They can never admit that, you know what, I may have misinterpreted this wrong. What's wrong with being human? Some people get things wrong. Judges get things wrong. Lawyers get things wrong. I've gotten things wrong in life. Why do y'all come to these spaces acting like everything you say is 1,000% correct? Just 1,000% correct. And when you're challenged from a legal standpoint, now anyone who challenged you from a legal standpoint, now they're wrong. Do you think people with that mindset are ever going to sustain long-lasting success? But come on. He did not, however, allege a Fifth Amendment takings claims until he filed his response, stating that the government did take private property, DNA, cDNA, fingerprints, footprints, retina scans, energy, etc., without providing just compensation. In its reply, the government rightfully notes that a party may not present new legal theories in response to a motion to dismiss. You know what that is? That's called the court rules and procedure. As I always coin it, it's the nuances of court. What did I say? They're going to nitpick the hell out you in the rules of procedure. 98% of the people that go to court don't understand the rules of procedure of court. That is a procedural violation. The court agrees and therefore may not rule on Mr. Davenport's Fifth Amendment takings claims. And you know what's so crazy about that? The government basically said, we're not even going to entertain that claim because he didn't follow the procedure. So they don't even have to get into it. Even though it's still frivolous, that's the easy way out for the lawyers. You know, pro se, yeah, I know y'all be giving the lawyers a way out the way you word your claims. Like, they don't even have to address your issues. All they got to do is just hit you on the procedural violations. And these are why people get frustrated and tell you to stay out of court. In the event that Mr. Davenport argues that he indeed made a Fifth Amendment takings claim in his complaint, as he referenced this amendment twice, once generally and next specifically identifying the due process clause, the court will address this claim, generally referring to a Fifth Amendment identifying a particular cause. In doing so, the court finds that Mr. Davenport's argument fails for three reasons. So even though the court said, you know what, we're going to entertain your takers clause claims, it's still going to fail. Remember when I said it's going to fail anyway? Remember I said it's going to fail anyway? First, Mr. Davenport's takings claims is founded upon the sovereign citizen theory rejected by the court. Now, we're not just talking about his specific claims. The claims that the government took your property via your birth certificate, via your social security card, all those claims fall under this theory. This is why they tell you to stay out of court. This is why they tell you don't go to court. Send those documents to the Treasury. But you know what the Treasury attorneys going to do when they see those documents? It's going to write in the shredder because case law is already out on it. If the courts have already rejected it, what makes you think the administrative agency is going to allow it? But they'll tell you that. As in such, it has no merit. Second, the Tucker Act confers jurisdiction in connection with claims against the United States. Mr. Davenport does not, however, explains the federal government's involvement in the alleged taking of his biological information. He refers to biological information perhaps taken by the state, but does not explain the federal government's connection to this alleged taking. These are the little things of court. These are the particularities that you got to have with your complaints. You can't just throw it out. And this is a typical sovereign citizen pro se complaint. You throw it out there, but you never expound. You never do the who, what, when, where, how. You throw it out there and then you move on. And plaintiff fails to specifically allege that the federal government was involved in the taking. The claim must fail for lack of subject matter jurisdiction. Further, the court does not exercise jurisdiction over claims against individual states. So any claims that the state of Georgia, for example, effectuated the taking in this case also fails for lack of subject matter jurisdiction. Lastly, Mr. Davenport alleges that his taking occurred in 1991, over 26 years ago. A 6-year statute of limitation applies to the Fifth Amendment takings claims. So all of you who just found out that your property was taken at birth, guess what? Guess what? The original taking was at birth, right? So that means you would have had to bring a claim against the government when you were 6 years old, or your parents bring it on your behalf. That alone kills your theory. As Mr. Davenport's takings claim surpasses the limitations period, it is again not within the court's jurisdiction. And you know what? The court is not leaving the door open like, oh, there may be a chance for someone to do it right. The court is just use a procedure to deny it because he can. He don't even have to expound. Finally, the Tucker Act grants jurisdiction to this court based on the money mandating provisions or a contractual relationship between the plaintiff and the United States. As explained above, Mr. Davenport's claims fail for lack of subject matter jurisdiction, as they are not grounded in money mandating provisions or simply cannot be heard before this court. Regarding a contractual relationship, the only other route to recovery, Mr. Davenport concedes that no contract exists between him and the government. Agreeing that his claims are not based on the contractual provisions with the government, Mr. Davenport extinguishes any possibility of recovery on that theory. For the reasons stated above, the government's motion to dismiss is granted. Mr. Davenport's motion for summary judgment is denied. The clerk of court shall enter judgment accordingly. No cause. It is so ordered. This is what you're going to get when you continue to follow these sovereign citizen theories, regardless if you don't go by the name or not. Regardless if you don't go by the, just because you reject the name doesn't make your documents to be looked at any different. I know they tell you, well, take this word out. Don't put this word here, because if you put this word here, they're going to do it like, nope. Nope. No. So let's no, we're not gonna do this one. We're not gonna do this one. Actually, we can do this one. We could do this one. I told y'all this is from 2022. John Lee Basie versus United States. Pro se. Sovereign citizen allegations dismissed for lack of subject matter jurisdiction. Now pending before the court is pro se plaintiff John Lee Basie's motion to seal these proceedings and the defendant United States motion to dismiss. Mr. Basie, a Texas state inmate, once again, another person locked up trying to use this to get out. But it's not because of their situation and them being locked up. It's the same ideologies. Mr. Basie, a Texas state inmate, has filed a complaint in this court alleging that when his name is spelled in capital letters, such as on his birth certificate or court filings, his name does not identify him. Rather, he argues that his name in capital letters identifies his corporate entity, a legal fiction controlled by the government. He alleges that when the United States issued his birth certificate, the government placed him, the living man, as a quasi-corporation surety for the all-caps name Private Business Trust, and that this was done without his knowledge or consent. Now tell me that this is what they talk about online every day. So you mean to tell me this is not the theories online? Remember, if what you're saying is true, you should be able to step into court and get your claims acknowledged. This is the part that I don't get. If it's so true, it could be true from a legal, it should be true from an administrative standpoint, from a legal standpoint. It shouldn't matter which venue you go in. If it's legit, if it's true, if it has merit, why all the pushback? Mr. Basie therefore claims that the issuance of his birth certificate created a unilateral contract by fraud for the sole benefit of the government. He requests, among other injunctive relief, that the court order his release from prison and that any and all past or present cases shall be void, nunc pro tunc, ab initio. He additionally asked the court order the United States Treasury to discharge all debts attached to his private business trust estate. This is the same core theories that you see people. These are the core theories. And set up a monthly allowance for his use and enjoyment. He seeks $250 million in damages. What did I tell you? All they had to do was tell you that you had a bottomless pit of money, and everybody who never even smelt the type of money that they're putting on their documents and their claims today, they are going to start 250 million, 100 million. Let me buy this house for 1.7 million. You get what I'm saying? They are putting these outrageous numbers on these documents because they believe there's some trust that's going to eventually pay it for them. Going to pay it for them. This is why they're doing what they're doing. This is why you go type up that negotiable instrument and send it into your auto company to pay your car note or to pay off the balance. And I guarantee you, when you write it up, you're not writing it on the account that you have direct access to right now. You're not writing it on your checking account, your savings account, or taking out your MMA account or your investment account. Hell, you're not even taking out your 401k. You're writing it based on the fact that it doesn't matter the amount because I'm not going to be responsible for it. Someone else can pay. It becomes, it becomes so sad that many people have fallen into this pit of desperation that they will literally make fools out of themselves. No self-respect, no self-pride. Several weeks, he talking about the motion to dismiss. We ain't gotta get into all that. I mean, get down here. The government then filed a motion to dismiss Mr. Basie's claims, arguing that the court lacks subject matter jurisdiction, or alternatively, that Mr. Basie has failed to state a claim upon which relief can be granted. The government argued that the complaint neither identifies a viable contract with the United States nor a money mandating source of law as required by the Tucker Act. So, instead asserts claims under a sovereign citizen theory of recovery, which the court has rejected on several prior occasions. I find it very interesting that everybody that's talking about we got this accounts, we got all this stuff, we can do this, they can never find a direct statute that confirms it, which you need in the Court of Federal Claims. You notice that? So when I put that video out this morning, the government never authorized it. It was never an act of Congress to set up accounts. Money can only be issued from the Treasury through an act of Congress or appropriations. If every other time money is spent in this country, every other time that money is printed up is either act of Congress or voted on for appropriations. Why is it that the process that has been running the same for the government for hundreds of years, it just so stops when it gets to us in the secret account? Why is it that any other time you get a monthly statement under federal law when you have money sitting in an account? Why hasn't the government sent us a monthly statement? They'll do it if you got other accounts with them. They'll send you a statement. Oh, but for this, it's a secret. But if it's so much of a secret, how do you know? The mere fact that people are trying to teach that is evidence that people 40 years ago were teaching the same thing. They're just following the footsteps. For the reasons discussed below, the court denies Mr. Basie's motion to seal and grants the government's motion to dismiss. Beginning first with Mr. Basie's we ain't got to worry about the seal. Like we ain't gonna worry about the seal. Let's get down to it. So the court next turned to the government's motion to dismiss for subject matter jurisdiction, lack of subject matter, under rules of the United States Court of Federal Claims. They don't even read the Court of Federal Claims rules before they put these frivolous complaints together. Under the Tucker Act, the action may be maintained in this court if it is founded either upon the Constitution or any act of Congress or any regulation of an executive department or any express or implied contract with the United States. So I have a question right there. These are all the grounds which you could bring a claim against the government. Why is it that none of you can ever point to a rule, regulation, statute, constitution, implied or express contract? Why is it that you can't find one? Want to know why? Because, as I've been trying to say for the past few years, it doesn't exist. You were duped by Roger Elvick. Roger Elvick created the secret account theory. Roger Elvick had ties to the white supremacist movement. Now look at my African-American brethren and brothers and sisters. Y'all be taking y'all beliefs and ideologies from white supremacists. You see what I'm saying? You don't even know the origins of what you do. Now, while somewhat difficult to follow, Mr. Basie's complaint is based on an alleged contract with the government, with the United States, that was purportedly created by his birth certificate. What do I tell you? They're always going to throw the birth certificate in there. That is the core belief. This is why people go get their birth certificates authenticated. These are the core beliefs. Why am I talking about this? Because these are the core inner beliefs that drives everything that you do in these spaces. When you remove these core beliefs, that means what the ways that you're going about trying to get what you're trying to get, you're not going to do it anymore because it's not lining up anymore. If you knew that every time you will make a claim like this, it would be rejected. If you knew that from the beginning, would you have ever made these claims? Mr. Basie is proceeding under the discredited sovereign citizen theory. Gravity versus United States, Potter versus United States, Davenport. Proponents of this theory believe that prior to the passage of the 14th Amendment, people were citizens only of their original states. Gravit. Following the passage of the 14th Amendment, sovereign citizen plaintiffs believe that the government uses birth certificates and social security documents as contracts to trick individuals into becoming United States citizens. You see, that is what was in every redemption manual, every Sovereign Solutions websites. That is the core belief of every redemption movement, patriot movement, moor movement, or get your rights movement, or the Tatanka, the trust people, the Indians. Now we Indians now all of a sudden. Trust Indian Tatankas. It's the core beliefs. It's the core beliefs. The government then uses these birth certificates and social security documents as security for the national debt. And this security interest creates individual trust fund accounts that contains each person's lifetime profits. Sovereign citizen plaintiffs often make a distinction between their names written in all capital letters and the same names written, just the initial letters capitalized, arguing that when they use the proper capitalization of their names, they can then redeem the funds held by the United States. But once again, what's the difference between the people who think like this and rejects the name sovereign citizen than the people who think like this and accepts the name and asserts the name, I'm a sovereign citizen? What is the difference? What's the core difference? What's the core difference? If you're being honest with yourself and you're being honest with me, there is no core difference. Sovereign citizen plaintiffs, okay, we did that. Sovereign citizen plaintiffs also believe that they're not subject to government authority. An attempt to, among other things, avoid paying taxes, extinguish debts, and derail criminal proceedings and civil proceedings at that. What is that? Once again, what's the difference between the ones who say I'm a sovereign citizen and the ones who not? They both think the same. This court has previously dismissed for lack of jurisdiction complaints invoking this theory. And you know what they're going to say? Yeah, that's what they're going to say. Why would they want to tell you it's true? That's what they're going to say. See, you're tricked. They want you to believe that. Okay, let's say I give you that. So you're not going to be able to go to any court with this because they're going to reject it. The IRS has already put out publishings citing that the courts have already rejected this. You can't go to your bank with this. They're going to reject it. You can't attempt to pay your mortgage doing this. They're going to reject it. You can't attempt to pay your auto off with this belief system. They're going to reject it. Who's going to accept it? Now, I think that's a good question. Who is going to accept these arguments then? If you go anywhere in any three branches of government, they're going to reject it. Who's going to accept it? The only ones who are going to accept it are the people who think like you. Nobody in the real world is going to accept this. Only the people who think like you. Likewise, here the court lacks jurisdiction over Basie's sovereign citizen claims. Mr. Basie's complaint contains commonly used sovereign citizen language. For example, Mr. Basie argues that the government created a unilateral contract by fraud when it issued his birth certificate. He contends that the 14th Amendment was instrumental in shifting citizenship of each American from being primarily a state citizen to being a private corporation of the government. I mean, what is so different from what he's saying than what you see online every day? And this ain't about this person, the court case. This is about what many people teach, advocate, and the driving force for them doing what they do. He claims that his name in all capital letters refers to a separate legal entity. He also seeks the return of any and all accounts held by the government as part of his private business trust estate. Look, we don't have to go far. We ain't gotta go far. Look. Just look.
For everybody that's trying to monetize their birth certificate bond, first you're going to need your QSIP number. So let's locate the QSIP number and find out how much the bond is worth.
What is that birth certificate bond? What is she doing? Going on the ancient old fidelity crap. What year is this? What do you know? 2023. They talk about, it looks like Fidelity has found out people are aware of their birth certificates are worth money and blocking. Your birth certificates there's not even, see, they don't understand how securities work. In order for security to have value, it has to be backed by a financial asset that is producing cash flow. Prime example, I have this. I issued the Supreme Elite Team trust note. I established a trust. These are the trust notes. I established the trust. The trust is full. I place contracts. I place 250 contracts with all these agreements where people are going to pay me anywhere from $1,000 to $10,000 a month. See, this is the underlying contract that backs the trust note. When they make their payments to me, I then take that money minus my cut because I jack the interest rate up so I can take a little off the top and put that there and do that and do what I do so I can make money too. But the rest of the principal and interest is going to pay the trust note holders. There is nothing that is liquid about a birth certificate. Look.
First, you're going to need to go to fidelity.com and sign in. Once you get there, you're going to hit like the little 3 bars up there on the side. After you hit that, you're going to go to news and research. After entering that news and research tab, you're going to hit birth certificate number right there. That might bring you to a page that looks like this. Enter it again inside of there. Okay, so there it goes. That's the stock symbol right there. That is the birth certificate number that I used. I blocked it out. So
the funds that are matching, no, they're not matching it like that. The numbers there, they got fund numbers. They're in sequential order. Some numbers in it may just match that fund number. But this has nothing to do with your, I told you they misinterpreted. So if I say 48932, if there's a fund number that has those numbers in it, then it's going, the system thinks that, oh, you must be talking about this fund number. There's nothing here that is legit. Nothing.
I'm not just putting information out like that. And that's the same name into the fund finder. As you can see, I'm using the same stock symbol, and that's the same name and stuff.
MRX, which you cross the first round. MRX. I guarantee you, if you look at the products, it has nothing to, I'm telling you. And let me just say that's what she's doing is true. Let's just, for the sake of argument. Somebody already invested in that fund. Somebody is being paid. It don't work. So this is what y'all wanted to do. Y'all want to find out where your bond is at and then go capture the bond. Then go capture the bond. You don't even realize that the people who are entitled to payment are the registered beneficiaries. They're already recorded. So if you're not registered, you're not even going to get a payment anyway. And this is why they know this is true, so they run the tax route with it. Yo, this is becoming scary. 1 second, y'all.
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is a blueprint. Supreme Elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme Elite team, university. Turn the credit star into currency.
Well, they be trying to get over.
That was on there. Same information.
Let's get back to it. Let's get back to it. Look at this crap.
So all of that will bring you to a page that looks like that now.
Look, see all this right here? See, this the manager. This the yield to date. This is how much people are the ones who are going to invest in it. This is what they're getting. I guarantee you, look, call these people the fund managers. I guarantee you, they'll be like, what the hell are you talking about? The QSIP number is for the securities that they issuing, not from your birth certificate. Your birth certificate. Look, she is scamming live, bro. That shit's a scam. Look.
What's up, guys? This is, I guess, part 2 of does the birth certificate actually have value?
Look, now all this right here, this has nothing to do with a government site saying it. This is one of those propaganda, one of those confirmation bias sites. These are one of those confirmation bias sites that's telling what you want to hear.
Yes. Some people wanted me to flip the camera. I know I didn't realize when I was recording it that it was going to record backwards. So I'm going to apologize because it's never going to be perfect, guys. You know, it's on the screen.
He's reading for 2018. That vital record, that's what I'm saying. They be misinterpreted. Look, I've been studying deeply for years. Look, down the wrong path for years. You want to know why he's studying deeply? When I studying deeply, want to know why? Want to know why? Because he heard free money. And soon as people hear free money, hey, let me go to rabbit hole. Let me go. Let me go. What I got to do next? All right, authenticate your birth certificate. You got. You want to learn the process? Give me $250. All right, here. That ain't work. What'd you do now? Oh, no, you ain't get the embossal. Oh, that's another. I give it to you for $500. All right, get this money. What's next? Went there, took it to they rejected. Nah. You missed the bond paper. Give me $100. I'm gonna send you the special bond paper. Oh, okay. Hey, nothing still happened. No. See, we gotta dye the bond paper. It's a special dye that you gotta put on the bond paper. How much is the bond? Oh, that's only $175. It's a special dye because when they touch it, like it got to process through the scanner in the system in a special way, the secret way. Okay, here's $175. All right, look, nothing happened. No, because you were supposed to put it on the tax form. You never said. I did. I said, remember, once you get all that stuff, you might have to come back to me for the taxes. You don't remember? I sent you the text. I didn't get no text. Oh, damn! Look. I've been dealing with so many people. Hold on, let me go ahead and type it up right quick and then making sure like I didn't send it. I'm just going to leave it in the box, but I'm not going to send it. Hold on. See, it's right here. Oh, see, look. It never sent. I forgot to send it. Oh, well, how much is for the tax? $600. I'll do the tax for you. All right. Boom. Get it? Bam. IRS response. Courts have considered claims like yours to be frivolous and may be subject to penalties. Hey, this is what they sent. Hey, hold on. Let me call you right back. All right. He don't call back. He called back because now he like, damn. Now the reality start to sit in. Damn, I done gave you like $23,000. Your call's been recorded to it. Voicemail. Your call's been recorded to it. Hey, man, that's fucked up, man. You're scamming. Block. Next live. Yo, got the birth certificate process, y'all. That's all it is. That's all it is. That's all this shit is. Look, birth certificate.
I created. I'm the government, and I created a document, and it has the same name as you. So would you agree that this document represents you? Please sign it.
There you go. There you go. Look, authenticate your
What if
birth
I told you you were worth millions of dollars and you didn't even know it? And what if I could prove it to you? And that you have a trust fund, and you're all trust fund babies.
I told you, that's how to get everybody in. That's how to get everybody. That's how you start. What if you know? Well, how do you know that you got all this money in the trust? You know, look at this right here. There's not been one person that is collected on these bonds. Prove me wrong. Now look at everybody. You think they would come back and tell you? Look at this now. You think they would come back and tell you? You think you would come back and tell you? You think you could come back? Look, I told you. So they'll tell you the process. Then if it just so happened to work for you, you will never know. Look, you see how stupid you think they would come back and tell you? Well, you done told the goddamn process. Why wouldn't you tell if you got $80 million? Like, why wouldn't you tell if you got $80 million? Why wouldn't you tell? What's see how secret it gets now when it gets down to the black and white facts? You were absolutely correct. Authenticating the birth certificate does absolutely nothing, but it's a piece of misinformation in this community that is used continuously. I've met so many people on path with this information that have done the authentication and nothing has changed in their life whatsoever. Nobody can offer any legal reference either on why it is done. They just do it because some internet guru told them to do it. That is amazing.
You're rocking with the best.
Shout out to her.
You're rocking with the best.
That is one of the first coherent statements I ever seen.
You're rocking with the best.
I know. We know. Look, any such person will have to
chew on this one.
What if I told you?
Look at this right here. Look at the mindset.
Chew on this.
Shit.
What if I told you you were worth millions?
Look at the mindset. Now it's any such person will have to sign a non-disclosure now. Now look at it. Now you got to sign a non-disclosure. Because of everyone trying to figure out a secret process instead of uniting us, the people, and demanding what is our money should not be an issue. God did not put a man on a work the week thing till he dies and don't believe. He gave us everything we need for free. We're the only species on the planet that's the pay to live. Only thing you choose is where you live and work. That job comes before. Shut up. The Bible says you don't work, you don't eat. After we finish the paperwork, how long till we get our hundreds of millions of dollars? I told you that is the only reason why people are even doing this stuff. That is the only reason why people are doing this stuff. This is the only reason. This is the only reason. Yeah, we can't win individually. They will pluck you out. It's the whole country. They wanted him dead for what he knew. Rest in peace, David. You can't collect it physically, but you can connect the bridge and pay off bills, cars, homes, etc. Now, here's the thing. Look at this. Look what he said, right? He's saying you can pay off bills, cars, homes, right? This is the person that made the statement. Law student, right? Now look on the channel. Nothing that shows that he paid it off. Nothing. I told you. They come, give their little, yeah, you can do this and do this, and get the fuck on. Looks like he remodels and does remodeling work. Don't look like he's looks like he does remodeling work. Don't look like he's living out a secret trust account. And don't look like it. I don't see no secret trust account living here. Look, you don't. I told you it. They all do the same.
What if I told you you were worth millions of dollars? And
they
you didn't
all
even know
do the same shit. Now look at this.
I could not wait to do this video. Authenticating your birth certificate is just one of the many requirements for achieving status correction, and I'll explain. For one, let's get a clear understanding on exactly what status correction is. When one corrects their status, they are pledging their allegiance to the state in which they were born. And
you're already that via the 14th Amendment. Pledging your, what does that mean? Explain what that means.
Do this by rescinding and revoking the contracts that you have in place with that guardian. You are declaring yourself harmless and to hold indemnity. You are also
straight out the redemption manual. Straight out the redemption manual. That is straight out the redemption manual. That's all it is. Straight out the redemption manual. The seal is entitled to full faith and credit. That just means the seals are valid and the person who fixes said seals has the authority to do so. That's exactly what it means. Look at this. Look at this reply. Look, no reply. Where do I take my birth certificate to get it authenticated? You see the mindset? It's always a step by step. What do I do next? What do I do? What do I do? What do I say? How do I walk? How do I talk? What do I do? What am I supposed to do next? Okay, I did this. What's the next step? Just like fucking robot. What do I do next? Do I talk? How do I walk? Do I put my left foot before my right foot? How do I do it? What's next? What the fuck? God damn. Look at this shit. What do I do? Where do I take it? You take it and shove it up your ass. How do you find your estate with that birth certificate? What if you were born abroad? Look, no response. How much does it cost? Part 2, can you make a folder, please? Department of State takes 5 weeks by mail. That's the longest process. I'd like to know, how do I go about authenticating my birth certificate? What about if you're married? Can you still do it? Thank you so much for posting. You are truly appreciated. And you know what they do? They do some stupid shit like, we got to protect her at all costs. We got to protect him. Y'all, let's protect him. You ain't going to do shit. You ain't protecting nothing. Let's protect him. Thank you so much. Help, please. Look, help. I know this is important. How can you do this? I need help with this for sure. I have a newborn. I need this money. I need the money to get my life in order. Please, somebody help me. I need money. The fuck? She also obtained each 3 birth certificates. I only have the city of. Supposedly there was also state county. How? Mother, what did I do if I was born in a state I don't reside in? I was born in Oklahoma, but I lived and resided in North Carolina from the age of then you go to North Carolina. These stupid ass. So how can I find out if you're free from one of the tribes you speak of? Thank you for sharing this information. Can one authenticate a copy? BCs are copies. We never received the original. Please bring clarity. Thank you. Look at you. It just keeps going on and on. She's educated and pressure. I want to be alive. Now let thirst trapping in the comments. Let me see. Let me look at her again.
preparing your declaration of irrevocable trust.
Yeah, she's decent. So an authenticated birth certificate puts you in control of the certificate of birth and not the state correct. Look, it just keeps going on and on and on and on with this garb. Now,
get in here. I got one of the biggest secrets and gifts for you. Now, have you ever heard about the birth certificate is sold on the stock market? Well, I got the receipts. And don't ask me how did I get them. Please do not ask me how did I get them in my inbox, as long as you got it, okay? As long as you got it. Now, I went back in my records and found this because I got tired of it. Everybody kept saying, oh, they selling our birth certificates. That's why it's on bond paper and blah, blah, blah. Now, you have the proof and the receipts. Thanks to Gaddy. Say thank you, Gaddy. But let's continue. Now be quiet, but watch. Look at this. I marked it in.
How did I fucking know? How did I fucking know it was going to be the same document that you see on Scribd? How did I know this is a fake document? Individual surety bonds, international promissory notes, bills of exchange, international. The United States never even became a party to the Uncitral Convention, which would even give the District of Columbia. I told you, yo, these are the same. They really be, international promissory note. Now let's go back here for a second. Let's go back here. Because neither birth certificates nor social security numbers recognize or impose contractual rights, obligations, or duties. Mr. Basie fails to make any credible allegation that his birth certificate formed a contract between himself and the United States. While a non-frivolous allegation that a contract exists between the plaintiff and the United States is sufficient to invoke this court's jurisdiction, Mr. Basie's allegations are so wholly insubstantial that dismissal for lack of subject matter jurisdiction is appropriate. Now, when you go here, look at this world. Look at the world on here. Look at the world on this app. The same app you on. Look at this world. You see this world? Look at that world. You see that world? You see that world? Let me focus y'all better. You see that world? Now, when you get to this world, this is when the reality hits you. This is when the reality hits you. And what's the end result right here? Government's motion to dismiss is granted and the complaint dismissed without prejudice. But brother, I thought you had the receipts.
I marked it in green for you.
Look.
So you can have it. You can go in and take a screenshot if you like. Here go the other half.
I don't even want to waste up storage in my phone screenshotting that garbage. So, once again, listen, it never fails. Everything it's an angle to extract money out y'all. Now, let's go here for a second. I'm so tired of these international promissory note people. I'm so tired. Okay, let's go here. For you international promissory note people, tap the screen, share the live. Can y'all please just take a few seconds out, YouTube and TikTok, and just share or tag the teachers that talks about this international promissory note? Please, if you can just do that, just tag them in the comments or share it, please. I really want to read this case in front of them because this is a federal case. Please, I would like to. And if you haven't already,
don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. War stories in the fine lines.
Let's go. Here we go. I'm trying to put you in a better position. I think that would be good. Pro se plaintiff Stephen L. Marvin. This was back in 2016. Hold on. I gotta lay another foundation. Let me lay a hold on. Before we do that, let's lay a foundation. Enter international promissory note. Because you know they're going to try to use this to pay their auto loans, their credit card cases. Look, there you go. Look. JP Morgan, look, payoff. Isn't that the... Hold on. Look, right in... Look, just writing the shit on there. Look. Hold on. Here's the thing, though. There you go, right here. Look.
Hold on. It's right here. Let me pause it. It's right here. Look. It's right here. It said, look, we do not accept. See, they wrote him back. We do not accept or negotiate promissory notes. See, he cut it off right there. Look. We do not accept or negotiate. Request to look, we don't accept it. What they tell you? He tried to get a deposit. They don't accept it. See? We do not accept or negotiate promissory notes. See, that's what's gonna happen when you try to. That's how you're gonna make a fool out of yourself. You try to send it to your bank. So we got an international promissory note, and you notice that they always post stuff like this. You notice that when they post it, right? They're always posting this part of it, right? What you never see them post is
here to show up and show out. Here to show up and show out. What? Here to show up and show out. Here to show up and show out.
You never see them post this part of it after the fact. You never see them post this side of it. You don't never see them post that side of it, but you're gonna see them post. Hold up. But you're gonna see them. This what you're gonna see them post though. This what you're gonna see them post. You're gonna see them post this.
1600 block. I just wanna rock.
Look.
I just wanna. I just wanna rock. Body out of ya. Shorty got that body out of ya. Hit it once.
And you know, and look at the biggest red flag. Look at the red flag. It worked. It worked. Before you say you can find this on the internet, please upload. Before you can find an international promissory note on the internet, hold on. We're going to get to that case. International promissory note? Which one you talk? Look, the claim is you can't find it on the internet. There you go. Hold on. You see that? You see that? Before you say you can find this on the internet, please upload. Okay. There you go right there. Yo, they think people so stupid. Yo, they didn't even listen. Look, that's what it said. TikTok friend sent me this and did it with bond paper and worked with Wells Fargo. Where's the results? Where the results? Where the results? See, look, 2023, where the results? They just come on here and play in y'all faces. That's all they do. They think y'all so green and desperate that y'all just going to give your money to them. All they got to do is tell you what sounds good. Look, just look at that. And we about to get to that case. I'm still waiting.
Here to show up and show out. 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 Yeah. Here to show up and show out. Here to show up and show out.
I'm still waiting. I'm still waiting. I am still waiting. Haven't seen one yet. See, I've been advised that credit acceptance mailed the lien release to you. It should arrive to you by early next week. See the difference?
See how we ain't gotta go through all. Look, I'm still waiting. I'm still waiting. So what do we have? So look at all these international promissory notes.
So what we're looking at right now is a promissory note, also known as a banker's acceptance. So just take your time.
It's a fake check. It's a fake fraudulent negotiable instrument.
With reading all of these fine prints up here, pull up some of these codes on your own.
Hey, let me ask yourself a question, right? When you got a paycheck from your job or someone paid you in a check, did they ever have codes and stuff on there? Did they ever have codes and stuff on there? Huh? I mean, why do you have to have codes and stuff on the check? You ever notice that? Why do you have to tell them it's a check? Don't you think they already know it's a check? Don't you think they, like when you see a normal, everyday, regular check, it just has to pay your account route number. Why all this extra stuff here? An obligation of the United States. Title 12 U.S.C. Section 411. 18 U.S.C. Section 8. UCC 1 on there. What did I tell you about 18 U.S.C. Section 12 Section 8? 18 U.S.C. Section 8, 12 U.S.C., the two statutes that gives you no right anyway. But if it's such legal and legit, why don't you just have the payee sign the account route number, put the number in and go cash it? Why you got to add all that extra stuff to it? That's a red flag. That is fraudulent. Okay? That's a red flag. That is a red flag. So let's go to this case. Pro Se filed a complaint against defendant Capital One Bank. Named as Capital One. This matter is now before the courts on a motion to dismiss. This case, and before we get to it, I guarantee you, it may started off as the person paying the debt or never paying the debt, and then popped up with an international promissory note. See, this case from 2016, I told y'all everything on here is outdated and old. 25 years old. It's outdated. I say, yo, they've been using the internet. That's been since the 90s. No, it hasn't. It has to be new because I'm just believing it. And I think I'm Albert Einstein now because I figured out something no one else in the world knows. So I really think I'm better than what I really am, and I'm more important than what I really am. So you better not tell me this is all old. What do you mean? This case involves a dispute writing out a plaintiff's use of Capital One credit card. Plaintiff apparently incurred a credit card debt in the amount of $5,754.24. Plaintiffs, rather than paying the credit card debt with a check or money order, remember when I told you, when you see them use these negotiable instruments to pay their debts, it means two things, one or two things. They don't have the money to pay, or they just don't want to pay. That's all it means. There's nothing legitimate about what they're online telling you to do with these regards. It's all teaching you to commit fraud and scams. That's all this is. But don't listen to the new culture empire. After sending the first note, Capital One required plaintiff to send a second note along with a social security number, date of birth, and other specific data for submission to its fulfillment center for processing. Sometime prior to September 30, 2015, plaintiff sent the second promissory note in the amount of $5,000 with my wet ink signature on it, along with my thumbprint in red ink with numerous legal citations quoted on the face of the promissory note. Plaintiff's facts stated in part, the authority for the note was quoted to be, what is it? Public Policy 7310. 112 at large, and HJR 192 of June 5th, 1933. The CUSIP number was quoted, and the receipt of negotiable instrument should have discharged the credit card debt for a $5,000 reduction in debt. So the real balance, the full balance was $754.24, $5,754.24. He sent the negotiable instrument in for $5,000. In a letter dated October 6, 2015, Capital One advised plaintiff that it would be happy to research its request, but it needed additional information such as current address. So this is at one of the early stages with Capital One. They didn't know what was going on, so that's why they had to let's check into this. One thing about it, they ain't gonna turn no money down. Let's see if this is really it. Ultimately, look, see, they had to do their research first. So do you know what happens when they do their research? It's the same lens that I use. They use the legal lens to determine the validity of what's being sent. They had to go put their legal lens on it.
You're rocking with the best.
They had to put the legal lens on it. Ultimately, Capital One stated that it would not recognize it as payment. At some point prior to November 4, 2015, plaintiff contacted the CFPB. Remember, when they don't recognize it, now they get mad and start sending threats and get the enforcement agencies on it. With respect to his attempt to pay the credit card debt with a negotiable international promissory note. Yes, like these. Like shit like this. Shit like that. Yeah, shit like that. See Capital One letter. In the November 4th letter, Capital One advised plaintiff as follows. We don't accept your negotiable international promissory note as an offset, payment, presentment, or discharge of your debt. We only accept legal tender for payment on accounts, which is the same legal tender that they know the world accepts, which is the same legal tender that they paid debts before. But as soon as they get into a little financial turmoil or they realize that, oh, I don't got to pay my debts with this. I ain't got to pay my debts with this. All I got to do is do this, and I can keep my money in the government somewhere out there in the stratosphere, in the universe. They're supposed to be paying it for me.
You're rocking with the best.
And what did I tell you? It goes back to the core beliefs that we were reading in this case and reading in this case. It goes back to the core beliefs. These are the core beliefs. Told you, these are the core beliefs. HJR 192, government has secret accounts. They owe me money. According to the terms of your customer agreement, all payments made by mail must be in the form of a check or money order, payable in United States funds drawn on a financial institution located in the United States. We have not received a valid form of payment on this account since July 8, 2015. You see? You see? Remember what I said? Did your contract state that you can pay in this method of payment? Well, why didn't you have this instrument down as a stipulated as a valid method of payment when you got into the contract? Oh, because I didn't give a damn about the payment. I was all right with paying it the normal regular way until I couldn't pay the normal regular way. But one of the things that you notice, they have no problem using the line of credit. The problem comes when it's time to pay back. See, look, he used up $5,754.24, right? Now look what the court says. The court is already setting the tone. Rather than pay the credit card debt with a check or money order, he issues 2 separate promissory notes. Yo, they really think a promissory note is going to kill their debts. We are not in default or dishonor to you as claimed in your negotiable or international promissory note. The documents you sent contains inaccurate assertions attempting to void or eliminate a valid debt. Plaintiff alleged that Capital One wrongfully rejected his international promissory note and violated the disclosure doctrine. What? It's not even, never mind. I.e., the statutes require full disclosure of the amount of interest being charged, which defendant Capital One did, and the difference between the cash price and the credit price, which defendant did not. Plaintiff alleged that Capital One's actions in lending him money damaged him by creating a debt servitude and regulating him to the status of peonage, stating in pertinent part, as of the October 2015 statement, the plaintiff is allegedly to pay out $108.32 in interest and fees. The defendant creates money out of thin air and burdens the plaintiff through a debt slave. What did I tell you? What did I tell you? The vapor money theory. Yeah. The vapor money theory. Oh, you ain't loan me nothing. You create out of thin air. You ain't really gave me nothing. I don't got to pay it back now. Well, when did you find this out? When I was $5,724 in debt? Well, why didn't you figure it out from day one after you read the contract? Oh, because I didn't give a damn. I only care about swiping and got what I want. Yeah, but did you swipe the card? Yeah. What was wrong with the card in the moment you were swiping it? I don't know. Nothing. So what's wrong with the card now that you got to pay it back? What's wrong with their language now? You know, I get so tired when people always use this same old cliche. Well, I ain't find out to it too. I was already about. No, you didn't. No, you didn't. Because the same way you could have started doing your little research, going down your little rabbit holes, it's the same way you could have did your research on day one after you reviewed the contract and found out inconsistencies from day one. That's what I did. But everybody is not me. The manner in which defendant Capital One transact business made the plaintiff their debt slave. But you notice that Capital One, I guarantee you, he probably knocked on their door looking for credit instead of them just showing up in his living room. Take the credit. Come on, man. I ain't got the money. Still take it. We'll figure it out. You notice that these companies never really go ask them for anything. You notice how these people that always got a problem, they always run to the finance companies to get into debt. I thought you had a secret account. This shit is so easy to break down. The transaction methodology of the account managers involve instruction where the plaintiffs, whether a plaintiff aware of it or not, were commencing debt servitude under their species of payment, therein commencing a status of peonage against the plaintiff. This is an old sovereign citizen talking point. In the past, plaintiff made periodic alleged payments with actual dollars, Federal Reserve notes, medium of exchange, or legal tender that was earned through the fruits of his labors. These actual periodic payments made to defendant Capital One were for money defendant Capital One created out of thin air. You will lose that argument every time. Finally, plaintiff alleged that Capital One reported this as a disputed debt to Equifax. While plaintiff contends that this court has jurisdiction over this action pursuant to the Truth in Lending Act. Oh, there go TILA. He has not alleged the violation of any particular section of TILA. The only conceivable claim against Capital One would arise under 15 U.S.C. 1637, required disclosures by creditor, based on plaintiff's contention that the bank failed to make a disclosure, i.e., the bank had the duty to provide full disclosure of the fact that Capital One had no money to credit the plaintiffs until the plaintiff signed the credit application. This appears to be plaintiff's first claim for relief, in which he alleged that Capital One violated duty to disclose, stated in pertinent part, defendant Capital One breached the duty to provide full disclosure of the fact that Capital One had no money to credit the plaintiff until the plaintiff signed the credit application. At that point, the money is created out of thin air by plaintiff's promise to pay. You know what? These people are so far gone off first base. It just baffles me how they really believe the things that be coming out of their mouths is true. In the second claim for relief, plaintiff alleged that Capital One engaged in actual fraud, stated in pertinent part upon information believed defendant Capital One knew it was merely making there you go. This is what they say when they don't understand the underlying accountings, the underlying corporate finance structure, the underlinings. They all plug in an electronic bookkeeping entry and created money out of thin air prior to entering into the credit agreement with the plaintiff. This is 98% of people's understanding of the banking system. You take an application, you sign it. They go then create the money out the thin air. Take that money out the sky based on your promise to pay and essentially loan you your money back to you. That's 98% of people's understanding of the banking system. And 2 or 3
Title 12 statutes. About 2, they all cite the same ones. 12 U.S.C. 411, 12 U.S.C. 412. Those are 2 of the main ones. They don't, that's their understanding of the banking laws right there. Vapor money theory and 2 statutes that has no applicability to their consumer lending. That concealment of creation of money by electronic bookkeeping entry was very latent and not reasonably identifiable. Trying to put y'all in the loop. Maybe that's bad. Identifiable and ascertainable by plaintiff. The defendant misrepresented their authority by implementing and alleged agreements that bypass federal laws of the Board of Governors of the Federal Reserve policies on discharge payment methods approved in the Uniform Commercial Code. So remember when I made a video talking about everybody thinks the UCC is just the law of the land, the supreme law of the land. You know when you got that Uniform Commercial Code, supreme law of the land, you got that from the Redemption Manual. Even though you've never read the Redemption Manual, that's plastered all through the Redemption Manual. This is why everybody's so fixated on UCC 1-308, 1-201, 1-204. Right. The third claim is defendant committed slander of credit willfully against the plaintiff, while instructed plaintiff to send a second promissory note with additional data on it to later decide they cannot accept that note as a form of payment. Either. Finally, the fourth claim, defendants knew or should have known that Equifax is a data controller, and by the defendant not sending accurate data, such as original promissory notes, information, evidence, and related data in accurate form, the defendant committed defamation against the plaintiff. You want to notice when I look stuff like this, y'all, I look at the underlying mindset of the person that like you have to have a, like, no disrespect, but look at the overall spirit and intent and the mindset that you got to be in to do this stuff. So basically, you go get credit on your face and then you just don't pay it back. Morally, you know, like, I did go to these people to get credit. I mean, they would, because you would want someone to pay you back if you loaned them money. But we always look at it from a very selfish, narcissistic, like, I could just float across this life, get stuff on my face, don't pay it back. And when the inevitable happens and I have to face the consequences, I'm just going to start suing and bringing lawsuits and throw a hissy fit. But you use their credit. See, when we look at it that way, this when equity starts to come in. See, with me, I never, before I filed my lawsuit, when I found out all the violations with them, you notice that it wasn't until I was ready to file the lawsuit that I even said, forget that, I'm not paying you. I even offered them $10,000 for the vehicle based on the violations. Like, if they would have agreed to that amount, there would have never been a lawsuit. Hey, here's some violations on you. Look, I know I'm be able to prove this in court, so let me just give you $10,000 for the vehicle. Now, many people will be like, nah, don't give them nothing. But me, I believe in equity. I believe in equity going both ways. I believe in getting equity and I believe in giving equity. I try to do the right thing when I can do it all the time. I always first, the corporate finance, you be in compliance the whole way. You do the right thing on your end, because when it gets in court, they can never say shit like this. Well, you never paid back. You're delinquent. I can at least bring my arguments and say, hey, Your Honor, even though there were all these violations, I still paid on time. See, that's equity tipping in your favor. We online, we always want equity to happen for us, but we never want to give it. You cannot have that mindset that you could walk out in this world, get goods and services, and not have to be financially responsible for the repayment. If you don't want to pay it back, go into your secret trust fund account. Go into your secret trust fund account. If you don't want to, and that's the part that still baffles me. You don't want to pay it back, well, tap into your secret trust fund account then. Hold on, yeah, I got to put this on the charger. Give me 1 second. I got to put it on the charger.
So I got a wireless charger, ladies and gentlemen. So I know you want to read it, but y'all gonna have to y'all just gonna have to tap in with me right here, or you can come to the New Culture Empire on YouTube. But I got a charge. I'm at 6%. So even here. So let's go. Now, defendant's motion to dismiss. Capital One brings its motion pursuant to Federal Rules Civil Procedure 12B6, which seeks dismissal for failure to state a claim upon which relief can be granted. Right? So we've already talked about the requirements of surviving Rule 12B6 motion. But I will say this. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has facially plausible content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. So they get into the standards, right? Now, however, this liberal construction does not require the court to conjure up unpled allegations, nor can a court rewrite a complaint to include claims that were never presented. So the alleged transaction in this lawsuit are not complicated. Plaintiff incurred debt on a Capital One credit card. He had past credit card bills in dollars. Instead of continuing to pay his credit card bill in dollars, plaintiff sent Capital One a piece of paper in which he called an international promissory note. Remember, I told y'all how the story goes? The story starts off as them paying the debt. And then the payments stop, and here comes the worthless pieces of paper. It's the same story over and over. Give me 1 second. So yeah, and the thing that and this is what so let's get back here. Let's get back here, y'all. So can we stop and just take a second? You realize that I don't care how many FDCPA claims that they show you that they went online. Do you know the overwhelming majority of people are getting slammed in court when they don't pay their credit card debts back? I know they want you to think that, oh, you ain't got to pay back. We're just going to do this. You know, it doesn't work out like that every time. And when you start playing Russian roulette with your mortgages and your autos, you are really playing a very dangerous game. Y'all, this is why Set You is so valuable, because you won't even attempt these rabbit holes. It will be you. The overall mindset of what Set You instills in my students, you can't even put a price tag on it. There's been people that came to me, I had to give them the antidote of the sovereign citizen. They have been delivered from that path. I dipped them in the water, the Set You water. I baptized them in the Set You water. They came back up. Now they looking up balance sheets, reading their account. I don't have a problem with their drive and their persistence. They just channel it in all the wrong things. Now, when Capital One rejected this paper as payment, plaintiff filed this federal lawsuit demanding relief against Capital One. In his response to the motion for summary judgment, plaintiff attempts to justify the use of the international promissory note sent to Capital One, referring to the following statement set forth at the bottom of the second note. In as much as no lawful money of account exists in circulation, and pursuant to current UNCTAD convention, Stephen Lee Marvin Trust has no money to which to pay a debt. Because Stephen Lee Marvin Trust has no money to which to pay a debt, he has had to resort to tender this negotiable instrument pursuant to the UNCTAD conventions Articles 1 through 47 and 24 CFR 115-201. Do you want to know what the problem with that is? There is money to pay the debt. We can't spend money when it's convenient for us, when it benefits us. But when it's time to spend money to pay a debt, now there's no money to pay it. We got to stop that. It says it right on the Federal Reserve note. This is legal tender for all public and private debts. Can someone, I don't even need you to answer the question. We all know why they do this. It's two things. I can't afford to pay it, or I just don't want to pay it. There's nothing any more than these processes are about more than just getting out of accountability, evading accountability. The gist of plaintiff's argument is that there is no lawful money in circulation, that his personal international promissory note was authorized under the Uncharted Convention, and that Capital One violated federal and state law by refusing to accept it. This is nonsense. That's what the court said. This is nonsense. Matter of fact, just do it like this. I need to get me a stand, like a little tripod stand. That's what I need to get. I'm not in your way, am I? So let's go back up here. All right. This is nonsense. So the gist of plaintiff's argument is that there is no lawful money in circulation, that his personal international promissory note was authorized under the Uncharted Convention, and that Capital One violated federal and state law by refusing to accept it. How can it be federal law and state law if the promissory note is under the Uncharted Convention? That would be international trade law. Ladies and gentlemen, the United States never became a party to the Uncharted Convention. Established by the United Nations General Assembly in 1966, Uncharted plays an important role in developing important legal framework to facilitate international trade and investment. Plaintiff cannot pay his debt owed to Capital One by use of a purported international promissory note authorized under the Uncharted Convention because such note is not legal tender. See that in reference Walters? See that? See that Blocker versus U.S. Bank? Rejected mortgagors effect to discharge mortgage through delivery of an international promissory note drawn on the U.S. Treasury. They tried this back in 2013. Blocker versus U.S. Bank. So when we get to people like these people, now look at all this. Look at all these people, international promissory note. Look, cash is trash. Cash is only trash when you lack sufficient funds. Look at these international promissory note people. Look, just look. Look. Look at this right here. Look at all this. You see how you're being misled all day online on here? Look, see how you're being misled? See? Everybody's misleading you. Look at all these people. Look at all these people. Look at it gets sad. But look what the court's saying. See, on here, they're saying you can do it. But we get here, they're saying absolutely not. Because Blocker bought a lawsuit once they didn't accept their fraudulent international promissory note. See Choppin versus Green Team Services. Courts throughout the country have held that international promissory notes are not legal tender, rejected conspiracy theories that similarly argue international promissory notes and bills of exchange may discharge a mortgage of other debts. See, that's what they're saying online. But when we get to the legal lens, this is why many people don't like what I say, because I don't just talk out the side of my neck. And if you don't want to listen to me, I will let the judge tell you. Plaintiff's lawsuit is based upon what? I made a video about that. The vapor money theory, which has been routinely rejected by the courts. As one court explained, the vapor money, unlawful money, or redemption theories of debt are all in essence based on the premise that because the United States went off the gold standard in 1933 with the passage of H.J.R. 192, the United States has been bankrupt and lenders have been created unenforceable debts because they are lending credit rather than legal tender. So when I make those videos, when I made that comment in my live yesterday about H.J.R. 192, you best believe it's through hours and hours and thousands of documents of research, even reading and rereading the actual H.J.R. 192. I don't just say it on not, I investigate. And then we look at the legal lens. Why are we looking at the legal lens? Because they already tried to do it the administrative way, so they went to court to get it enforced. So this rejection is not a rejection of the international promissory note they tendered. It's a rejection of what they believe to be so true. And look at all these case laws too. With these strange and vague allegations, the pro se plaintiffs appear to be tempted to plead the theory known in the credit industry as a vapor money theory or no money lent theory, which is commonly pleaded in an effort to avoid legitimate debts. Case law after case law. Look, Demler versus Bank One. The court addressed the utterly frivolous nature of similar claims asserted by the plaintiff who sought to avoid paying back a $350,000 mortgage. What is the common denominator in all these people? They always get a loan on their face, and then they do these processes in lawsuits to avoid paying it. That's all it is. In this case, even taking plaintiff's pro se status into account, the court concludes that the complaint is utterly frivolous and lacks any legal foundation whatsoever. It would be a further waste of judicial resource to delve into the voluminous allegations contained in plaintiff's 21-count complaint. Suffice to say that all the plaintiff's claims, federal and state, stem from the same basic premise. Plaintiff alleges that the promissory note he executed is the equivalent of money that he gave to the bank. He contends that Bank One took his money, the promissory note, deposited into its own account without his permission, listed it as an asset on its ledger entries, and then essentially lent his own money back to him. What did I just say? That's their beliefs of the banking system 10 minutes ago. This is nothing more than a vapor money theory and the modern money mechanics allegations here. This is the modern. I made a video on TikTok about the modern money mechanics. I say, y'all keep thinking it works like that today. The modern money mechanics going to send you up shit's creek. And remember, when they don't understand accounting like we do in SETU, what do? They use general vague terms, asset, ledger entries. How does the ledger entry look? What's the classification on the entries? What's the classification on the item that's being entered into the ledger? What balance sheet is it associated with? What line number is associated with? Did you do your projected defaults yet? Did you do your discount amount? Did you do your ACLs on it? Is it in non-accrual status? What status? Is it impairment? What schedule are they using to calculate it? Are they using the amortization schedule? What are they doing? Are they doing the effective yield method? Like which see, these are questions that when you start getting up into corporate finance, people like this that you see online, they would be like a fish out of water. They'd be a humduck over a barrel. Would have no clue. He contends that Bank One did not actually have the funds available to lend him, but instead created the money through its bookkeeping procedures. See, remember I told you they'll plug in words like bookkeeping entries, bookkeeping procedures, when you're supposed to be very detailed into how they do it, because they don't understand corporate finance and they don't understand how these people work. He further argues that because Bank One was never at risk and provided no consideration, the promissory note is void ab initio. You know what we call that in court? We call that a legal conclusion. He made a legal conclusion. That's not for him to determine if the contract is void. That's for the judge to. Okay, I know they want to tell you that they know court. I know these are the things that they want you to know. I know these are the things that they want you to believe. I know these are the things, but I'm telling you, when a person that has years of experience in court, 98% of people on here never win. He further argued never at risk, providing consideration unlimited, and defendants' intent to foreclose on a mortgage are therefore unlawful. Plaintiff offers no authority for this patently ludicrous argument because the only authority that they have is places like this. This is their authority. This is their authority for the things that they do right here. This is their authority. This is their authority right here. This is their authority. All this is your authority. This is what you believe. Misinterpretations of congressional law, congressional records. Look.
What's up, guys? So in this video, I wanted to explain how to go about editing this international bill exchange document, because in that video that I watched.
Right. You see? Now, if we look here, this is one of the things I see. Look. Look. You see? You see? You see? Just look. Look at this same guy. This same guy, he's on TikTok now because YouTube done. Look. YouTube done, man. Yeah. Yeah. See? Like people like him, it's all the same shit. It's all the same shit. Give me 1 second. Yeah, I gotta grab it. Gotta grab something right quick.
Yeah, no, it's okay. That's okay. No, it's all right.
Yes.
It's just,
All right. Cool. And we heading out at 5 o'clock. Or we got to be there at 5:30. And then just put a free sign right there. Somebody get it. I mean, I don't put it down. We can put it down like at the end of the street somewhere. Yeah, just for free. Yeah, it's still a good couch. I don't want to throw it away. Somebody use it. So, yeah, y'all, we about to move into the big boy in a few here. But I'm on 8%, y'all. TikTok, y'all gonna have to just y'all gonna have to rock out. Y'all gonna have to rock out with me from right here because I'm on 8% and I need this to charge. Because it takes my phone forever to charge, y'all. For some reason, the port on the iPhone, the 16 Pro Max, my port is broken. So when I put this part into the port, it actually drains my battery. So if y'all got any tips on how I can do that, because they got all the remedies on TikTok. I'll be seeing that. Now, them little remedies, them little supplements and stuff, yeah, I'm with all that. But if y'all have any tips, please let me know. So he contends that Bank One, so plaintiff offers no authority for his patently ludicrous argument. Similar arguments have been rejected by federal courts across the country. And look, y'all, it's Francis Kinney Family Trust versus World Savings Bank, sanctioning plaintiffs and rejecting their vapor money theory, Carrington versus Federal National Mortgage. And look at these years, y'all. This is from 2005, the Kinney Family Trust. Another one, 2005, finding fundamentally absurd and obviously frivolous plaintiffs' claims that legal tender unlawfully created money through its ledger entries. Look at this, United States versus Shifen, rejected arguments that there was insufficient consideration to secure the promissory note and that lender had created money by means of bookkeeping entry. Thiel versus First Federal Savings and Loan Association of Marion, 1986. 1986, the argument was rejecting claims that lender had violated RICO and the National Bank Act by issuing loan check in exchange for promissory note and imposing sanctions on plaintiffs for bringing frivolous actions. These are the arguments that you see all day online on here. And he raised this in 1986. Here's another one. Renee versus Citibank, 1999. Rejecting claims that because lender did not have sufficient funds in his vault to make the loan and merely transferred some book entries, the lender had created illegal tender. You just 1999, almost 30 years ago. So when I say y'all, they've been making these arguments for the past 30, 40 years. I don't think y'all believe me. I don't think y'all believe me. I don't think y'all believe me. You're look at the case. Look at the case, y'all. Look at the case. Look at these cases. These are case law on the same arguments that you see online every day. These are the case laws. These are the case laws, rejecting them. The same international promise, the same vapor money, they didn't loan you nothing, rejecting it. But I'm the bad guy because I'm telling you, they've already argued after 30 years ago, it's been rejected. But I'm the bad guy. Plaintiff claims reek of tax protester or so-called sovereign citizen theory. You know what he said? Plaintiffs' claims reek. Lawsuits such as plaintiffs which seek to avoid debts because the creditor had no money to lend have been found to be brought in bad faith and sanctionable. You know what that means when he says bad faith? You're coming with the wrong intent. You're only doing this to get out of a debt. That's the only reason why you're bringing it. The courts see through it. You may tell yourself it's your rights. You may refer to the modern money mechanics. You may tell yourself, but the courts see it as you're just doing it to avoid your financial obligations. And look at the spirit and the intent that has to go into this. And then we wonder why many people are not getting results. It's not even the process that you're doing where you're not getting results. It's your inner spirit. That's why you're not getting the results. You know, I'm surprised all these spiritual people, universal law people, spiritual universal, you know, deep down in your soul, you're just trying to get over. Because if you were really, okay, I didn't know, you wouldn't continue to try different ways of going about it. You'd have been one and done. You wouldn't keep doing it because now you know. And I'm telling you, you can't separate the universal world. You can't separate that we got energy. They can connect. And what's the problem is your spirit and your intent are attracting you to people and situations that lead you to the places that you really don't want to go. But you really want to go there because your subconscious mind does not weigh whether this is good or bad for you. Your subconscious mind picks up on it. It goes out to the universe, and then you get the end results of what your subconscious mind, what's really on it. Look at it. You're looking for a quick way out. You're looking for a way not to be accountable. You're looking for shortcuts. You're desperate or greed or desperation. Look at those traits. Who is successful in real life who moves around with that spirit? Who is successful in real life? Who has long-lasting success? I'm not even bringing to you ain't get out your debts. I'm 100%, and I would defend anyone from here to kingdom come if we are being asked to pay more than what they even say themselves we owe. Or we're asked to pay on a contract that was dead from the beginning. So that's all it is. I don't mind paying, but I'm not going to pay so you can fill your coffers when the amounts that you ask me to pay, you can't legally substantiate it. The amounts that you can legally substantiate, I'll be more than willing to pay. but I'm not going to go about it doing things the wrong way. I'm not going to act and operate in bad faith, either for myself or just because you want me to. I'm not going to do it. You will never see me present anything like this for myself or anybody else. I don't care if you say, hey man, I give you an extra $2,000 to do it. The answer is going to be no. See, you're worried about you. I'm worried about my reputation. The answer is no. As the court observed in Nixon versus individual head of Joseph Mortgage College, finally, this lawsuit smacks of bad faith on the part of the plaintiff. Nixon obtained a check in September 1981 and used it to purchase his residence. In late 1984, after the mortgage company begins proceedings to foreclose the mortgage, Nixon suddenly files this suit seeking, in effect, to have the loan with which he obtained his residence declared illegal so as to back out of his contractual promise to pay the loan. They've been seeing this stuff since 1981. This is a 1981 case. Nixon versus individual head of St. Joseph Mortgage Company. Oh my gosh. He has enjoyed the fruits of what the mortgage company's checks bought, yet seeks to nullify that check on the basis of an absurd view that bank or mortgage company checks are worthless attempts to create illegal tender. Nixon's own experience in getting a residence with the check indicates that the marketplace recognizes the value of credit in checkbook money, so that Nixon has suffered no damages and has no valid claim to advance here. You know it's a benefit when they give you that line of credit. You know it's a benefit when they cut you that check. When Navy Federal cuts you that check and you can take it to the seller and purchase that vehicle, that's credit money. That's checkbook money. But you still reap the benefits of which you're going to come back and say, oh, that's illegal. But you are still benefited from it. But when you buy that vehicle with Navy Federal, what are you going to do? You're going to find a process to not give them the title. Give them the goddamn title. Do shit the right way. That's why you're not winning. Give them the damn title. How can you fight? You didn't even give them the title. Then we go do what we do. Don't worry about them playing fair. You make sure you're always in the best position you can be in. That can't be taught. That's just on the spirit of the individual. You can't be taught that. Either that's who you are or that's who you're not. I would never not give them the title. Nah, there's problems with this. Oh, I don't like this. I'm going to give you the title, though. Here, take the title for now. I'll see you in court. Not going to not, because when you don't give them the title, what makes you think they even want to work with you at all? You ain't showing no grace. You want to know why we made my settlement with credit acceptance go so smoothly? It's because I showed good faith throughout the whole thing. I could have buried them alive, but I held back and I showed good faith. I could have put so much shit on the record against them that they knew I had because I sent it to them in the email. I left it out. I didn't even talk about it. Oh, you made an appearance now? All right, I'm going here and withdraw my motion for entry of default. I didn't have to do that. They would have had to fight from up under that. I said, nah, don't worry, nah, we good. Hey, Jeffrey Gamble, since we talking, I'm gonna show good faith. I'm gonna withdraw that. Nah, I ain't gonna do that like that. Oh man, I would have never did that. But guess what? They gave me everything I asked for in my proposal. They gave me everything I asked for with no hesitation. You gotta start doing things the right way, man. Even though it may hurt, you gotta start doing things the right way. You gotta go about it the right way. The reason why many people in this picture, you're going about it the wrong way. You are going about it the wrong way. In Nixon's other two cases, this court found Nixon's claims frivolous and deserving of his sanctions under Rule 11 of the Federal Rules of Civil Procedure. This case warrants such sanctions as well, especially in light of the fact that Nixon used the allegedly worthless check to buy his home. Given the fact that this suit was filed near the time that the mortgage company began foreclosure proceedings against Nixon, there is also an element of attempting to harass these defendants through the filing of a dilatory and groundless lawsuits, a practice which the Seventh Circuit has found worthy of the imposition of sanctions. And a lot of people do is they file lawsuits to harass these companies. If you have a lawsuit, let the lawsuit be what it is. Let the lawsuit be legitimate. Let the merits of your lawsuit speak for you. But if you come with bad faith and you want to mask it as my rights, they're going to see you coming a mile away. And now you ain't got nothing coming. You know it's bad faith when you send a negotiable instrument in to try to pay off your auto or your mortgage. You know you're operating in bad faith. I don't care what HJR, I don't care what they put on the promissory note. You know deep down inside, you're not. You know that wasn't the method of payment that they would accept. Because if you would have came across, let's say you owe $300,000, they about to foreclose, but you need $20,000 to be back in the clear. You know if $50,000 stumbled across your lap, you know you wouldn't have sent that same international promissory note in. You would have got a certified check and you would have paid them that $25,000 to keep your house. You know you would have done that. Plaintiff's cryptic TILA disclosure claim, as well as his state law claims for fraud, slander of credit, and defamation are frivolous. They all arise from the groundless theories. One, that Capital One did not lend plaintiff money, but created it out of thin air. And two, that Capital One refused to accept plaintiff's worthless international promissory note to pay his credit card bill. For these reasons, plaintiff's allegations fail to state a claim to relief that is plausible on its face. Accordingly, his complaint should be dismissed. For the reasons set above, I respectfully recommend that defendant's motion to dismiss be granted and that this matter be dismissed. August 16th, 2016. Ray Kent, United States Magistrate Judge. This is what happens when you think that you're getting your law from here, from this TikTok app, or something.
What's up, guys? So
or Facebook. Facebook is a melting pot. This is what happens. This is what happens. This is what happens right here. Dismiss. And watch it. Any objection to his report would be served. So he got it if you want to appeal it. This is what happens. And let's go here. And I don't know how many times. I mean, it's probably not going to mean that the people are so far gone down, and they want to still do it because they feel like they have no, I guess, no hope or whatever, or no one can tell them that they're wrong. But I'm gonna tell you this. I'm gonna tell you this though. I'm going to tell you this. If you continue to think that you are going to get some free money and chasing that money, life is going to be way harder for you than what you believe. Like Double Lion Uche Express Trust versus United States. They're looking for 580 something million. Look, like Ra Kuti Amenbe. I told you these raw Ka, ancient Egyptian, Osiris, the Eye of Horus people. They are the biggest scammers. They are the biggest desperate, greed-driven people. I don't care that your avatar has an Egyptian king and you're standing up like this. I don't give a shit about none of that. Standing like this, two up, two down. I don't give a shit about that. You could use that ancient esoteric shit to mask that you're committing frauds and scams. That's all that ancient esoteric shit mean over here. That's all it is. 419 million. Suing the government for 419 million. And that's that, you know, the worst thing they could have ever done was say there's some free money for you. That is the first thing that they could have ever done. United States versus Gravit. That was the worst thing they could have ever done to people. It's like they stopped. It's over from there. It's over from there. So you've seen plenty of case laws today. Actually, oh, hold on. Let's go here. Let's go here. Now, this was, I did this 6 months ago. They don't know case law. They don't know federal rules of civil procedure. They don't know local rules. They don't know court strategy. They don't know litigation. They don't know litigation strategy. Court is not just putting all your facts in there, throwing it. It's a strategy. It's timing. It's know when to file a motion, know when not to file a motion, know when to appeal, when to appeal on discovery, subpoena duca secum, interrogatories, admissions. Got to know when to do your Dory voir jury instructions. Got to know how to structure them. Got to know how to do this. Got to know how to object. Got to know how to argue. Got to know how to. They know court is so complex. That's why they stay out of court. I love court. So, without explaining that he is the entitlement holder of his estate. He is declared alive and to be compensated the interest from the estate. So, the first document titled Notice and Warning to Utility Companies. Wasn't she trying to do stuff with her bills? Why am I sharing this? Because this sums up everything Coach MT was saying in that video. This is what it's going to look like when they don't honor administratively and you got to go to court. This is what it looks like. The key allegation in this document is a reference to the bankruptcy, quote unquote, of the United States. You see that? Bankruptcy of the United States. And nobody can tell me that I'm lying. That's true. That's not true. I gave you case law reference cases as early as 1981. So when I say 98% of the processes that you see online en masse are all old, outdated, 40 years old claims, please, if I'm wrong, prove me through case law that I'm wrong.
You're rocking with the best.
Prove me through case law that I'm wrong. That purportedly occurred in 1933. House Joint Resolution was passed in 1933. We only have debt because all property and gold were seized by the government as collateral in the bankruptcy of the United States, end quote. The document also, but here's the thing that they always leave out. The gold was seized in 1933, the executive order of April 1st. But why didn't they tell them everybody got their just compensation? Because they got legal tender in exchange. See, that kills that, or they took the gold, we can't pay our debts now. Number two, you wasn't even alive when it happened. When we was operating in full-fledged fiat currency system by the time you were born. So there was never going to be any payments that you was going to get in gold anyway. You see how logic destroys 98% of these claims? Logic. Includes the following passage, presented without alteration. So he sends this to a judge, but expects the judge to have enough jurisdiction over him to give him what he wants. But this is what he said. Every judge and every attorney in America, especially those who hold position with several direct connections into the utilities company's bank accounts and acting as attorneys for the banks, most presumably in all other countries as well, since they all get their instructions from England, the same place that all banks get their instructions through the comptroller of the currency, headquarters in London, England, even though the headquarters for the comptroller of the currency is in Washington, D.C. Each knowing the above and incorporated to be true, since they are well versed on U.S. bankruptcy of 1933, and that America still remains in a state of emergency, even though the emergency related to the March 9th, 1933 Emergency Banking Act ended in 1978. You see how a propaganda document is spewing all misinformation and painting a picture that it wants people that believe to believe, but then all you gotta do is look back over history and the actual facts of what happened will dispute that document. People never research the documents that they read. They get it, it's saying things that they want to hear, and they take it as face value. They never research it. There is the state of emergency from the banking holidays from March 6th to March 9th, 1933 has been suspended. It ended in 1978, even though it legally ended in 1978. And that's, you can look that up. Remember I said, if you don't know what to look up, you're not going to know what to look up. And all the things you need to know and look up, it's never going to come across because it's not in here. Well, the Supreme Elite Team Group, we put that in here. Under English law, though it's supposed to be a well-kept secret, this means there is no money. It further means that since there is no money, America's signatures are used as the credit to run this country. He attached this. He didn't write this. That comes from his own research. This is out the redemption manual or the other sovereign citizen documents. So they take the sovereign citizen documents and attach it to their court case because this bridges the gaps to their lack of understanding and their lack of reasoning on how to coherently break it down. So they'll be like, look, judge, it says it right here in this sovereign citizen document. It must be true. That in turn means that it is the American people who are creditors, not the debtors. That's what Coach MT was saying, as the bank and utility companies would like everyone to believe. The second document is schedule of fees, through which plaintiff purports to establish specific monetary penalties for various infractions related to the trust, which owns the copyright, trademark, and name, Marcel Lamar, James Lamar Wood. For example, unsolicited interrogation of the trustee for the trust as to that person's name or driver's license is a $10,000 infraction. Requiring a signature under threat, duress, or coercion is a $1 million infraction. But none of them has ever got their fee schedules cashed out. And then he provides a first will and testament of the grantor, which grantor purports to identify information for the estate that is the basis for his claim. And I told you, they all, the whole thing of turning your case or your all caps and putting it in the trust and then going to represent the trust in court, that was something that they stopped in 1998 because the courts were not recognizing it. They were doing that from like 93 to 98, trying that. That's a whole old process. Oh, get your trust. Come into court under the trust. That's old. That's not new. That's old. That's over 30 years old. Boy, my gosh, we gotta catch up. And what they do is they get their parents to assign the estate over to their child. So they get their parents to sign the document. So this is what all this is. I, Sheila Mack, being a sound mind over age of 50, as grantor of the private security trust estate, Marcel James Lamar Wood, registrant number, date of registration, do bless and grant irrevocable power of attorney over said trust security to my son, Marcel J. L. Wood. So that's what they do. They'll get their parents, because I guess the parents are the grantor in the birth certificate and the application. So they get their parents to sign their signatures. Hey, I grant over to your son. That's an old process. They was doing that 20 years ago. Ages and or sizes 2022. And then he had an affidavit of correction. You notice they never filed motions or memorandums of law on points. They're always going to do affidavits and notices in the courts. Even though the courts commonly say you want to interact with the judge, you have to file a motion or a pleading, and then the opposing counsel must have a copy of it, and then they hold a hearing on it. That's true. They never respond with motions and pleadings. They respond with affidavits and notices. So once again, and I'm starting to believe that many people just don't want to look up the stuff that I'm saying because they're scared what they're going to find. So, national emergency is a situation in which the government is empowered to perform acts not normally permitted. The 1976 National Emergency Acts implemented various legal requirements regarding emergencies declared by the President of the United States. As of July 2025, 90 emergencies have been declared. 42 have expired, and another 51 are currently in effect, each having been given renewed annually by the President. So, checking the first door. Did you? No, it's supposed to be another one. So if you look here, so you got the President, you got the status, start date, end date, source documents, title. You can go right here. Franklin Roosevelt. You see that? Status, ended. What's that? Remember that? March 6, 1933. Remember? War and emergency war powers. Remember March 6th to March 9th? It was a national bank holiday. You see what it says? Ended. You see when it ended? September 14th, 1978. See this? Right here. Amendments. See? I told you they have a problem because their belief systems, it gets crushed with reality. Amendments to the Trading with the Enemy Act. Section 5B1 of the Trading with the Enemy Act is amended by striking out during or any other period of national emergency declared by President. Right? The authorities conferred upon the President by Section 5B of the Trading with the Enemy Act, which were being exercised with respect to a country on July 1st, 1977. See, that's not even around, still had no applicability. As a result of a national emergency declared by the President before such date, may continue to be exercised with respect to such country, except that unless extended, the exercise shall terminate at the end of the 2-year beginning on the date of enactment of the National Emergencies Act. So, this right here, first in 1976, but the termination right here, 50 U.S.C., it was terminated in 1978. This is what did it. This is what did it. All this right here. Right here. All this right here. So remember when granted authorities, this is what did it. Right here. These are authorities that is terminated because there's no more transaction with foreign enemies that's in this country around the time. There's no transaction. This is what public law. All this is what ended it. Ended it right here. So when you see, so when I made a comment, I probably won't be able to find it on. It's on here. When I made a comment of the young girl talking about, oh, this is how you cannot be an enemy anymore. You got to do this, build it with the Office of Foreign Asset Control. There is no alien property custodian office anymore. It was terminated in 1983. But they know your arguments. They know they made their arguments. Then the judge rules. That's how court works. I'm just blowing smoke. No, not with them. They could sucker bit. I'm just blowing smoke up your ass. They know. They all know. Yes, the emergency terminated in 1978. But nobody wants to circumvent the court rules and get straight to affidavits. Next two documents, affidavit of knowledge of facts. So when it boils down to it, to determine whether the court has jurisdiction, because that's the number one thing. Does the court have jurisdiction over your claim? And if the court has jurisdiction, all right, y'all. I got to end this now because I have to. We got to get ready. We got to get ready to do what we need to do. I got to get up out of here in a second. Take care of some business. But the moral of the story is 98% of what is going on online in these spaces are nothing more than the regurgitated sovereign citizen theories. What we do over in Set U, we don't do none of this. We don't even waste our time. Talk about it because content, try to give some insight to people. But we do things on a professional level, and we do things on a level that's actually going to lead to results, as you've already been seeing.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Professionally taught, professional approved. Make Set U your next move. So I find it, why is going into court so much of a bad thing when millions of companies and millions of corporations go into court every day to settle disputes? They settle disputes every day by going into court. But now we're not supposed to go into court.
His documents are so powerful. They think it's artificial intelligence. Scalpel engaged, another myth is sight, ready to be destroyed.
You're rocking with the best.
Gotcha, bitch!
This show is not suitable for all audiences. Listener discretion is advised.
Consumer autos, get this. If you want to make the money free, you can talk about taxes when you're in your mortgage space, auto carriers. If you want your pass the court rules, then at least you get the cash. The first thing is they're not filing a motion to dismiss or judgment. Please reach out or a properly styled complaint.
You're rocking with the DJ that keeps the hits coming.
Gotcha, bitch!
Credit no, I couldn't let them get me caught in front of the house inside Mercedes Benz GLE was something wasn't right. I had to do it right. Yeah. Sent the email with the proof. Then I filed a suit.
You're rocking with the best.
Then they called the truth. Leave just like that. Gone. They settled quick, title on the way, and the debt was wiped away, and I ain't even had to pay. No, push the whip with a drip. You know I got the stick. You know I say the case. You know that they legit. Hey, proceed be the way. If you know how to play, get the win, drop order, then you get on out of the way. 50K right away. Thomas, I did it right. Now these haters gotta say that Thomas did it right. Go real talk about what to do, but Thomas did it right. No guessing about the law, cause Thomas did it right. Interest rates high, but Thomas couldn't stand.
I do got one thing to say before I go. I do got one to say. Let me ask yourselves a question. At this point, what else do you have to lose? No. Ask yourself this question. What else do you have to lose? Just what else do you have to lose? I mean, come on now. Your bills are not going to be paid by international promissory note. There's no secret shortcut way to get out your debt. That is a strategic process that you have to do and understand. There's no quick get my title back by submitting a document. If you want to commit title fraud and title washing, you get your title when the underlying debt is legally satisfied, whether through payment or otherwise through court. If you don't feel like the amount that's presented on your contract represents or reflects the economic reality and what they say you really owe, then reach out. If you just need me to look at it, want me to audit your contract, we'll do that. Just look at it. If you're unsure, Sunday, I'll be releasing one of my mortgage justice live class. If you want to pull up to, not a live class, my mortgage justice class. If you want to pull up to the mortgage justice replay game, it's not going to be on here. It's going to be on StreamYard, and only those who receive the link will go. I'll upload it here, and we'll watch the class together. If you got any questions, I'll stop. Need me to refer you to some cases? We'll stop and research some cases together. We'll have a glass of wine together. If you do your little puff the chiba, you can bring your ashtray with you. Yeah. Sit back, get your tablet. If you got your family and friends around, got your husband and wife around, you can put this thing on speaker. Let them listen, and we'll break it down. So I'll do that for you. I'll present that for you. It will be a nominal fee to get the link, though. But at least you can know that, okay, at least he's already been successful in the classes that he held and the things that he teach. At least he's already been there, done that. At least there's already members in this group that's been there, done that as well. At least that's why I'm speaking from experience. I know what you're going through. I know where these rabbit holes can take you. I've spent hours and years investigating it. And the only reason why I'm saying it doesn't work because I'm applying the legal lens to it. When you put these claims in court, it all depends on how it's structured, the arguments raised, and the timing of the arguments. That's it. That all that belief theory goes out the. This is not even what I believe is true. This is just what it is. I've been through the fire. I've been through the ringer already. I've been battle tested many times. Like I'm gonna call the courts to get that order with Wesley. Made them drop out the case right at trial. These are things that are measurable. These things are verified. You never know. I may pull back some of the professional documents I study from. We may go over a little bit of that. You never know. But you always get more than what you paid for. I tell you that much. But that's what I think we'll do. It's the mortgage justice class series that I had last year. I think it was 9 videos. The mortgage justice class. It's 9 videos. Night 1 was a banger. I remember night 1. And we're going over case law. We're going over authoritative case law. And if you don't get anything from there, at least you'll be like, okay, so at least this is kind of the right way to start attacking the mortgage. This is kind of the right way to do it. And then we'll probably go over a document or two. We'll probably go over a checklist, what you need. And then after that, if you feel like, hey man, hey, let's sign up, you can sign up. It don't make no difference. It really don't make no difference to me. I'm just tired of seeing people spend money on garbage and bullshit that I know is not going to work when they could be spending it over here and actually get some goddamn work done. Shit. Yeah. I'm trying to take the money out of the guru's pockets, put it in my pockets. You're going to get more. You're going to get more. You're going to get more out of it than what you paid. Yeah, I know I call clients. You know, you see me call my clients. We got a case coming up May 21st. A hearing on a response that was a year late. Why was the response a year late? These online gurus. But when it comes to lawsuits, ladies and gentlemen, nah. I trust me. Unless you are a top elite professional, there's nobody out here in these spaces that can. Because remember, I started off legal work first. I started off legal. Then I moved to the finance. I started off criminal first, which is way more harder than civil. I already started out in court. Told you I was a snidget away from beating the federal government. So yeah, I think I'll do that. If you're interested, send me a DM or you can send me an email at thomaslegacy603@gmail.com. If you're a Supreme Elite Team member group and you were already in the official class, then you can pull back up for the replay because I'm pulling it out the archives. You won't have to pay if you was already in that original class. I think, yeah. Yeah. And pull up, and we're gonna do the mortgage justice Sunday. We're gonna do the mortgage justice where we're fighting and filing for justice. Let me see if I actually got the mortgage. Hold on, let me see if I got it. It's in my archives. Yeah, it's in my archives. Hold on, let me see if I can pull it up. See, this is, hold on, YouTube. This is all in my archives. Look at the archives. Class 7. Look at the archives. Look at the archives. Look, class 4. SEC and more. Mortgage finance. Accounting. Class meetup. Why should I join Set U? Pre-class, Supreme Elite Team. Meetup, court, the saws. All right. Welcome to another. Oh shit. Hold on. How do I get out of it? I'd have left YouTube hanging. Hold on. Let me share my screen. Share entire screen. Look. Pull the curtain back right quick. Class, the Supreme Elite Team. Breaking news. I just got this information. Actually, I didn't check. I just checked my email about 20 minutes ago. This email was sent earlier today. If you don't know, credit acceptance agrees to settle. January 23rd this year. Credit acceptance agrees to settle.
Congratulations, big guy. Congratulations.
Thank you, bro.
Yeah, boy. Congratulations.
Congrats, bro. Thanks, bro.
Very proud.
Congrats, man, on the scout.
But listen, Cat, real talk, man. I don't know why you didn't already know this.
That's what I'm thinking. Because here's the thing. Just because the sun rises and sets every day, that still don't mean that I know what's going to do it.
Notice how I'm not cocky. It's my group members. We're still humble. Still 11 something. What is it? Damn it. 11:14 at night. Just off a settlement. Still with the mob.
You know what I'm saying? You gotta think about it. Like, think about it. I don't know. Let's be honest. They know if saying that there are major benefits for this system the way it is. We all benefit from it. Let's not act like we don't benefit from it as well. Lines of credit, that's a benefit. You get your credit up front, you pay back over time. You leave the dealership with a vehicle, you pay back over time. You get a whole goddamn house up front, you pay back over time. Okay, without this system, the way that is, you got to buy all that shit outright.
You see, everything I'm telling you, I'm telling my group. You see me saying, we're not doing this, we ain't paying. Yeah, that's none of that in my group. None of that in my
And
group.
I never lose sight of that. One of the benefits is you get access to the goods and services. Up front, of course, you probably got to make a down payment outright. If the system changed the way most of these people wanted front, of course, you probably got to make a down payment. Notice that they ran their happy asses down to get into that contract. They ain't going, and just talking, they don't know shit. Anyone that's on Facebook post, tell Kenyatta Stone to produce that. Tell Kenyatta Stone, tell these social media gurus, tell them to produce this or the equivalent. And you know what's another act of good faith on their behalf? Wanna know why? Hey y'all, listen, let me just keep it 100. They know I could have stepped up with the entry of default.
Hopefully these terms are satisfactory and that we can move forward with preparing the settlement. Given the status of our settlement discussions, I would propose that we table discussion of arbitration, as that issue may become moot if a settlement can be reached. Because they said, when he first reached out, he said credit acceptance is going to move for arbitration. I said, no, they won't. I said, in my mind, I said, no, they won't. So when I sent them my proposal, I reinforced, hey, if we don't settle, this is what I'm going to prove. This is what I'm going to prove by preponderance of evidence. Arbitration is going to be invalidated. See, I invalidate arbitration clause. I don't be like, oh, we're going to go to arbitration. I invalidate that clause right from the contract.
You know that, right? They know I had them. With the controlling case law, actual notice. They know if I would have doubled down on that, they know they would have lost. Why do you think they kept asking me, like, yo, yeah, and guess what? I didn't even file it yet, but I sent it to them, the notice of withdrawal, just to show y'all I'm operating in good faith. I'm operating in good faith, y'all.
What I just got done telling y'all? Huh? What did I just got done telling? I'm not telling y'all nothing that I don't. I live what I teach. I live it. I'm a living example of what I teach.
And let's be honest. They know if I would have doubled down on that entry of default, they'd have been stuck with the default because I had Fourth Circuit precedents that would have showed that they got actual notice and they were, hold on, I'm not, yo, come on, man, I do this shit. We do this shit, y'all. The Supreme Elite team is not going half step. See, this is the bullshit that I'm talking about.
I don't know why my docs always.
This is all bullshit that I'm this. Let me show you. It'd be so helpful, man, if we could just get that notice of withdrawal, man. You know, we have to focus that time on that because the entry of default means the entry, you know what the entry of default means? Even though, listen, I know for showing for good cause that they could come back in.
And this is what I did. I did that for them. Since the filing that request, defendant has appeared through counsel and commits with plaintiffs regarding a waiver of service in their defense of the operative complaint filed. In addition, plaintiff and defense counsel have engaged in preliminary potential settlement of this dispute. In light of this development, in the interest of judicial efficiency and good faith cooperations, plaintiff hereby withdraws his prior request for entry of default.
And I know that the judge know, but if I would have doubled that,
how many people would have done that? You know, that could have that
on it. I would have again probably would have been like, you know what, you pro se, we ain't going. And now there's no other teacher out there pro se with.
That's enough right there. You're getting too much now. You're getting too much. You're getting too much. You're getting too much. You are getting too much. Which one was this?
Said you is not going to be like Telegram. You know how we have it in here. It's not Streets of the Republic. Look very different from the types of cases of the last 50.
We going over here. Look, talking about the courts. And a judge wrote this on the rise of pro se litigants. Talk to the mindset of the courts, how they view pro se litigants. See, we go over real, get into the mindset of pro se litigants, so we can know, all right, how did the judge view these things? How they doing? How they look at it? Hold on, all right, we got to make sure. Look, initial response to pro se litigants. We're going over the mindset of pro se litigants. Over the mindset of pro se litigants. We're going over that.
Think that when the pro se litigant, when their case get dismissed at the initial stage, the judge gives them a right to amend their complaint and refile. But if it was a lawyer that did that, it's just being dismissed without prejudice. You get what I'm saying? Lawyers don't get the option to refile again once the complaint gets dismissed. They don't get the option. It's over with.
See? What else we had? Court talk. Key moments. Take key moments from that. Write those cases or those sames down, and then transpose it. Strategy. You want to become filing counter plaintiff at the pretrial stage, discovery stage. That's when you want to slap it on them. See, there are stages in court for a reason. The two things that you have to get past is the initial complaint stage and surviving a summary judgment motion. Every professional lawyer on Wall Street would tell you those are the two things that we have to survive before we can take it to them. Actually, I was watching man, it's just, oh my God, like, my group, they are being put together. They are being, oh my gosh, this one right here.
You're making an argument, and you'll see this a lot in pro se litigants when they're so focused on the facts of their case versus the rules and the procedural vehicle to drive their claims into the court.
I ain't telling you no different than I ain't telling you my group. It's behind the curtain. Sneak me.
Anytime you see an argument that is heavily on, they did this, and the understanding of it. See, most people think the information and knowledge is enough. That doesn't mean nothing. Understanding it, putting it in a legal form, proper form.
The controversy is right because plaintiff's obligations, CAC's ongoing collection process, and CAC's own accounting policies and disclosures converge on a single factual question: whether CAC has already realized through securitization, financing proceeds, and recognize the economic obligations, such as seeing collection attempts. Whoa, I gotta keep going.
If we put a payoff quote, that means we still trying to get out of it. So it's a trap for I wish they would.
This right here.
We have one.
This right here was what dead on it right here.
Even absent active litigation or garnishment, plaintiff has an interest in the present value in the accurate.
Yeah, let me not. Yeah, it's too much. I'm giving y'all a little too much. Ooh, the master netting class. Talking about how they net the accounts on the books to show up how what class overview. Just okay, audit report. Talk about securitization here.
Either admitting, showing up, or yeah, I acknowledge that, but and I'm like, oh my God. It was cringy in court today. I'm like, oh no, don't say that. And all I kept seeing today is always tell you how to win when they get you their opinion. They always tell you how to win. They all tell you how to win.
One second.
And this is why we have a judicial system, and we have rights, we have appellate rights, we have other type of actions, and you gotta go through the judicial system.
Notice how I'm not saying stay away from court. We're gonna do this process. Stay away from court. We're not gonna win in court. They're not gonna recognize it. Not over here.
And I know it's a lot of money to be made in the courts, but I'm telling y'all that, especially out there in that small town, Ohio, there was no way. As a matter of fact, it's a preconceived notion. I was actually looking for the actual the law form, but I gotta find it. That's all I had. I mean, like, after I sent them that letter. I said, you want to do that? Okay, let's go. How many times I try to tell y'all that wasn't my credit card? But I still want to come. I said, okay. I gave him 2 opportunities. I said, okay, what's your address? We just gonna take it there. Midland. This is Midland.
Thank you for your recent communication. We have reviewed our records and writing to provide you the following. We have closed your account and ceased collections. You have no further obligation regarding this account. See, when you're legally removing the underlying obligations, they're going to notify you. There's no, oh, we did this process. They didn't respond. It's done. Oh, we won. Yeah. No. When it's legally done, you ain't got to worry about it. They're going to let you know. See, I didn't have to do an FDCPA claim. See, I just talk directly to them because we speak their language over here. Hey, if you want to go to court, if you want to take me to court, cool. This is how I'm coming. You're not going to be able to get around it.
We have closed your account and cease collections. You have no further obligation regarding this account. I know I don't. I tried to tell you. But they don't understand anything but the blood, guts, and gore. To
tell you. And by means, I am no top attorney.
UW and risk factors. Look at my exhibit. Look, I'm putting together for the mortgage defense. Just putting them all together right here. What's on your risk factor? What do y'all not want to talk about? What do y'all not want to talk about? That's what I'm talking about. Yeah, this ain't no. This is top. Let me see. Man, it's the archives is crazy. The archives is crazy. I got so much. I can't let you see it all. I can't let y'all see it all. But all this is going to comprise of, look, securitization and bankruptcy. See, all this gonna end up being on a lot of this gonna end up being on what you call it? Look, got the forensic audit report. Look, the forensic audit report. A real QWR. I know what you're thinking. Let us see it. Look, balance sheet review. Sovereign citizen. Blickety mickety. Today on YouTube, I held a master class. Well, in a class, it was just a live stream. But it was a master class on why, if it's not this, you have nothing else.
I can see your screen though.
Yo, they changed all this up. Crazy. Because I know you see the term consumer finance transactions. There is no such thing as a consumer finance transaction. Why do they name it consumer finance? See? So, administration fees. Look. That's it. Showing how to read a balance sheet. Worried about getting a variation. Showing how to read a balance sheet. Making it impossible for the judge to just rule based on their complaint. Showing them how to read a balance sheet. Showing them how to understand the balance sheet. Understand these terms. Understand what these terms mean. Oh, yeah. Goes down. It goes down. I got to put it back on the charger. It goes down in the Supreme Elite team. All right, y'all. I can't continue to get you. I can't continue to let the screen. I let the curtain back just a snap bit, but it's more. It's got thousands of thousands. I got over 25,000 documents. I got over 25,000 documents. I got over 15,000 professional documents, professional manuals from the OCC, top one of the big four accounting firms. I got a whole library of all professional related shit. This is why it pays to be in the Supreme Elite team. All right, YouTube, I'm gonna catch y'all on the back end. One gone. Nope, that ain't end well. One gone.